that we should be moving away from the system we have, where Parliament decides what should and shouldn't happen on a matter of policy of this sort, and handing it over to judges for whatever interpretation of the law they may choose to come up with.
And again, a very valid, a very valid point, because that is here to be debated and for us to discuss today, and that is why it is. Does this being enshrined in a Bill of Rights actually work? Is that the political lever that is necessary? I don't necessarily believe that's the case, but I shall continue with my speech.
I thank my friend for giving way. And if I may, I'm very interested to hear what she has to say next, because it is not the opposition who are bringing forward a Bill of Rights or claiming to bring forward a Bill of Rights, and I'm sure that's one of the issues we might get into, whether or not the legislation presented does represent that. But the concept of a Bill of Rights has been brought into British politics. And so it is absolutely right that we discuss what should be enshrined in that legislation and whether that includes a woman's right to choose to have an abortion, which many of us feel is a human rights issue. Just because it has not come before, it is the very piece of legislation that brings the debate that I know she's about to bring for us that means that we need to have this conversation.
And I thank my honourable friend for her comments, because it is the Bill of Rights that has been discussed, that is to be brought forward, that that triggered Caitlin into wanting to protect women in this country, whether that happens or not. So this is what I wish to discuss. So, moving on. Abortion in Great Britain is still a criminal offence. The 1967 Abortion Act simply made abortion legal in certain fixed circumstances. And so it's a product of its time, enacted in part to ensure women no longer suffered serious health problems or even death because they were too afraid to seek medical help after an abortion. It's therefore ironic that its requirements, designed to pass a parliament of more than half a century ago, risk women's health. The Abortion Act, as we know, requires that 2 doctors approve each request for a termination, a legal requirement which serves no clinical or safety purpose, which often delays the process, despite abortion being safer the earlier it is performed. And the fact that abortion continues to sit in the criminal law has a chilling effect on medical practice and doctors' willingness to authorise abortions. In a conversation earlier with a very dear colleague, we discussed that did we actually know somebody that wasn't able to access these services? And through conversations that I've had, I've found out there are cases where this is the case, and I think that that's what we need to discuss and look at. The threat... I shall.
Thank you for giving way in this crucial debate. What about the aftercare of women? We're talking about changing the law, and a number of my constituents are very concerned that that would lead to abortion up till birth. And we know that there's about 80% of women who want the time limit reduced. But what about beyond that? That the mental health of women who've had abortion, where is the care for them? Where does this address anything that's never been properly addressed for years and years?
My honourable friend makes a very valid point about the aftercare of women who choose or choose not to have a termination. And that's something I feel personally very strongly about, that those cares, it may be years down the line that you may need that support, and that support is lacking. So I agree with her on that point, and it's something we need to discuss further. So, we really, just find my place again, sorry. This threat of prosecution is a real, is a real fear, and it's a fear also that deters doctors from wanting to enter into this fundamental area of women's healthcare. And so, we're really pleased to see early medical abortions being safely offered from GPs in other community settings, as it is in other countries. Mm-hmm. And the fact that all non-hospital-based services must be specifically licensed and approved by the Secretary of State can be a barrier to improving access. Women who are unable to travel to clinics because of distance, personal circumstances, maybe coercive relationships, medical conditions, are poorly served by the current framework. And if they take matters into their own hands by accessing pills online, they risk prosecution and prison. And this is a real concern. To talk of prosecution in these circumstances might seem laughable to some, but a recent Sunday Times investigation found that 52 women since 2015 have been reported to the police for allegedly breaking abortion laws. And I spoke to the British Pregnancy Advisory Service, and they're aware of multiple instances where the existing law that criminalises abortion has been used against women who have ended their own pregnancy. For example, some of the examples that have been given is a migrant woman in Oxford in 2021 obtained and self-administered medication in a failed attempt to end her own pregnancy. And when she was taken to hospital, the doctors performed a successful emergency C-section and seemingly then reported her to the police because they found the remnants of of medication in her vagina. So she's now a parent to a toddler, but is still being prosecuted for attempted procurement of a miscarriage. And last year in London, a woman was admitted to hospital in need of a surgical procedure to end her uterus after a stillbirth at 24 weeks, as a result of abortion care sought within a formal healthcare system. So, while she was on the ward post-procedure, she was arrested by the police and taken to a police station and kept in a police cell for 36 hours. I can't imagine any woman or girl ever wanting to be in this situation. It's just absolutely the most... When you grow up, when you're that little girl growing up, you just want to... You think about your lovely family, you think about the children you're going to have. You say, by the time I'm 24, I'm going to be married, I'm going to have 2.3 children, I'm going to live this life. And the hopes and the dreams of women when they find themselves in this situation is devastating to them because they don't want to be in that situation. They don't want to have been treated like that. And I feel very strongly that having this debate today is really important. Yes, I will.
Absolutely right. The sheer compassion this has to come out. I mean, there's something like 800,000 pregnancies in the United Kingdom last year. In the last 7 or 8 years, I think there's been 17 people brought up on the issue that the member has identified. Only 2 have been charged. So there's such a limited, narrow area that we're actually dealing with that it's not widespread. And I think that we need to keep that proportion there. And I think it's important that those matters have been put on the agenda by the member.
Well, to be totally frank, we should have decriminalisation. I don't believe there should be 1 or 2 or any woman be made to feel like that. When you have to do... It's very difficult. Well, fundamentally, and the Right Honourable Member knows that we will disagree, but the fact that we can have this debate is the most important thing. And I'll have to move on because I know we just won't agree. But again, it's important that everybody's views are heard. A 15-year-old girl was investigated by the police after a stillbirth at 28 weeks accused of an illegal abortion. Her phone, her laptop were confiscated during her GCSE exams, driven to self-harm by a year-long investigation. Really moments in a person's life, in a woman's life, that have been really, really impacted on. And it only concluded when the coroner found that the pregnancy had ended as a result of natural causes. Imagine going through that when you're going through your GCSEs, your whole life ahead of you. So the reality of criminalisation for the women investigated, their lives are being picked apart, they're being treated like criminals, and it causes huge disruption. They don't feel safe in accessing medical services. Their trust in the health service is undermined. And these women are often vulnerable women, children even, in desperate situations with complicated medical histories or mental health problems. But due to this approach with the CPS, You know, rather than being provided with support, in this moment, these women are facing a terrifying journey of criminalisation. And we talk about choice when it comes to abortion, but those who are currently empowered to make choices aren't the women who need these services. They are the police who choose to investigate, the CPS who decide to prosecute. And so the current law takes fundamental decisions about an individual's health care and hands it to the state. What's very concerning is that the law as it stands could potentially be overturned by the government of the day without a vote in Parliament. And this is where we need to look at maybe the position of the current Cabinet's view on a woman's ability to access reproductive health care, because we can see it's an issue far from settled. Now, it could be, and I don't wish to, I just want to point this out for the record. I don't, but it's seen that, the Prime Minister has abstained on all votes relating to abortion in England since becoming an MP, and that includes buffer zones and early medical abortion at home, the telemedicine that we saw this year. And the Chancellor has been vocal about his desire to halve the time limit in which women can have abortions from 24 weeks to 12 weeks, even breaking the whip. And we say it's a matter of conscience, so I understand. And also, the Home Secretary voted against telemedicine being made permanent and the legal enforcement of buffer zones in 2022. So we need to be thinking about these views, and therefore it is right that Caitlin worries, and others, the 150,000 signatures on that petition are concerned, because to look on and to look at our Parliament, there is that risk of it happening. So I totally understand where Caitlin was. Yes, I will.
I thank her for writing away. If this legal right to an abortion were to be introduced, would it also allow a legal right to a sex-selective abortion as well?
I don't read it like that, but I think there is a better way forward. But that is my personal opinion.
The motivation wouldn't be determined in advance.
Well, it's not that I would see it that way, but I do thank the honourable gentleman for bringing up that viewpoint. But it is incredibly important we don't shy away from these debates. If there's something that we can learn from the United States, is how not to discuss women's reproductive health. We can't allow something so important to become yet another salvo in the culture war, and that is down to us. This is down to us, because women deserve much better than that. And I'd like to end on that note, and I'd like to thank everybody for the interventions. I think it's very important that we discuss the way forward. I think that decriminalisation is very, very important, because no woman or young girl should feel that way about their future. Thank you, Chair.
The question is that this House has considered E-petition 619334 relating to legal rights to access abortion. Sir Edward Lee.
Serve under your chairmanship, Sir Graham. And I apologise, I'm chairing a bill upstairs, so I can't stay at the end of this debate. I do apologise. Now, we've recently seen MPs that want even wider laws on abortion hijack the government's public order bill to introduce buffers or censorship zones which aim to restrict fundamental freedoms of speech and expression against people's human rights. This would deny and criminalise those volunteers who offer support to women going to abortion clinics who don't really want to have an abortion, but are forced to, perhaps by abusive partners. We now have apparently some MPs, many of the same MPs, looking to hijack the government's Bill of Rights, also on abortion. The government is bringing forward this Bill of Rights as it seeks to remedy one of the worst mistakes of previous governments, namely the undemocratic reach of European human rights laws. The Bill of Rights is intended to deal with situations like illegal cross-channel migrants using human rights laws to evade justice, or terrorists hiding behind laws that were never meant to shield them from justice and scrutiny the way that they have. The bill, which was in the manifesto that I and my colleagues on my side of the room stood on in 2019, would give supremacy to the UK Supreme Court. That's all it does. and make it explicit that courts in this country can disregard rulings from the European Court of Human Rights. And by the way, those who favour more abortions should note that actually in practice, whatever may be the letter of the law, in practice we have one of the most liberal abortion rights in Europe. I wonder just how many of them actually would like to be under the control of the European Court of Human Rights, where many other countries in Europe have far more restrictive abortion laws. So I think they may be shooting themselves in the foot. I'll give away briefly, yes.
Thank you very much. I thank the honourable member for giving way, but I would just like to say that for many of us, for many women, it is not about what happens anywhere else in the world. It is about protecting a right, not for us personally, because many of us would not, we don't think, have an abortion ourselves, but protecting the ability of other women, of young women, to make that decision if necessary and if they feel it's right. And the problem with having a Bill of Rights which doesn't include it is that it excludes that right from them.
Well, the Honourable MP mentions a worry about what's happening in the rest of the world, and we've heard a lot about the United States of America, but we're in an entirely different situation here. If anybody wants to change the effective right to abortion, they have to come to Parliament. Parliament is supreme in this matter. So I'm not sure that women need to worry about what's happening in the United States. There's no way in which I or anybody else or anybody in any court of law in this country can restrict their rights to abortion, their effective rights. They have to come to Parliament. A bill has to be moved through Parliament. So it's disappointing that there are members, apparently in this House, even those who do not support the intentions behind the Bill of Rights, that see this as yet another opportunity to hijack flagship government legislation to further weaken the few laws and safeguards there are in the law that govern abortion. It's up to members in this House to vote to change the law on abortion, which we have a perfect right to do. Those of us who think the sheer scale of abortions is a failure in how we treat women and how we value life, at least know that this law was made by Parliament and so can be changed by Parliament. By making abortion a, quote, right, in contrast, the present laws would likely be enshrined and so would be beyond correcting, even when plainly needed. Now, let me give one widely accepted example. For instance, the law was changed in 1990 because the previous 28 weeks was considered too late a limit, given the science on viability had changed. Now science shows babies can survive at 22 weeks or earlier. And there are a lot of people who believe that the present limit of 24 weeks is therefore too high. In one ward of a hospital, it's possible for an abortion to be taking place, and the next ward, huge amounts of public resources, quite rightly, are being used to save a baby of 22 weeks gestation. But if a right were enshrined, the necessary change to stop the practice of late-term abortions would likely not be possible. And we've also had the very interesting point made by our honourable friend about gender selection. How would this be dealt with by Parliament in a Bill of Rights? The trouble with this sort of legislation is you can't frame legislation to cover every eventuality in a Bill of Rights. Much better that Parliament considers every practice, every change of a law, every advance in science on its merits. Yes.
I thank the honourable member for giving way. Would he agree with me? The hijacking of bills just makes bad law, because in Northern Ireland we have seen just that, where the law has been hijacked, and we now have a change from life-affirming laws, which the people of Northern Ireland support, to some of the most liberal abortion laws in all of Europe.
I think, yes, I agree with the Honourable. I think it's a very dangerous parliamentary and legal practice to try and achieve your aims by piggybacking those aims on a bill which is designed to deal with a completely different eventuality. The law as it stands effectively allows abortion on demand. We know that. We have a record 200,000 plus abortions per year, perhaps 1 in 4 in this country. That can be beyond doubt. And in reality, every woman who wants to have an abortion can obtain one. We do not need to include it in a Bill of Rights. Instead, we need to look at how the state has failed so many women that they feel abortion is the only option available to them, and to look at alternative modes of support. There is no real appetite to make it a right, aside from a vocal minority and various lobby groups, including the abortion providers themselves. A right to abortion would be a very strange thing indeed. The only right that we would regret using, and the only right we would ideally, actively seek to minimise. Nobody thinks that abortion is a good thing and they want more abortions. They may think it's necessary in certain circumstances, but it's not the sort of right we want to extend. This is contrast to other fundamental rights. So let's look at them. Freedom of speech, for instance, association, privacy, to name a few fundamental rights, which we do not seek to minimise, but which we cherish and value, and which we want to enframe in a Bill of Rights. I hope colleagues who want to drag this bill to a very different place rethink their plans. I was about to finish, but I'll give one more time.
Thank you, for giving way. That's very generous of him. I just wonder if he could clarify for me. He talks there passionately about the human right of freedom of speech. I agree with him. I feel very strongly about defending it, and I notice that this Bill of Rights talks about doing that and protecting it from interference. Can he explain to us what the difference would be in interfering in somebody's womb, which is what the human right to have an abortion would be? Why is it that this legislation is right to protect one right, but not another right? And why is it right this legislation would bring in the judges and give the direction to the courts on one issue, but not another?
Well, that's an interesting point. But is the freedom to have, say, an abortion at 24 weeks rather than 22 weeks the kind of fundamental right that we believe should be protected in a bill of rights? I mean, this is a matter for argument, isn't it? A Bill of Rights is an unbelievably blunt instrument to deal with this particular sensitive issue. And I do say to the Honourable Lady that if she is, or if any of us are dissatisfied with this law, and there are probably more on this side of the House who are dissatisfied with this present law than there are on the other side of the House, at least we have to come to Parliament. We have to convince our colleagues to change the law. And I don't believe, and I think many other people don't believe, that the Bill of Rights is the right way to do it.
Yeah. Senator Creasy.
Thank you, Sir Graham. It's a pleasure to serve under your chairmanship this afternoon, and I hope that this will be an important and I would say a light, not heat, debate, because I think perhaps in the past we've had too few of these, and I congratulate the member for Gower in setting that out so powerfully and making that argument. I also want to congratulate Caitlin for her petition. It's an incredibly powerful petition, and I think reflects a view that is growing, and indeed the majority amongst women in this country, that in the 21st century, their rights to healthcare need not just to be protected, but clarified. Let me start by stating something which I think is very important for us all to recognise, which is when you ban abortion, you don't stop abortion. You simply stop access to safe abortion. So when we talk about having a human right to abortion, the alternative is not no abortion. The alternative is unsafe abortion. There is no pro-life perspective on this. There are only those who recognise the need to ensure safe access, indeed to save lives, to prevent those unsafe abortions, and those who are more comfortable with the risks that may come from not offering such a service. Secondly, let me start with some clarification, because I do not believe the government has put before us, and maybe alternative wording will be brought forward, and perhaps the Minister can tell us this, a Bill of Rights. Because it does not set out a set of rights. Perhaps, I'm sure the member opposite will regale us with his stories about the American Constitution. I'm sure he's more of a scholar to that than I am. But that sets out a series of rights. This bill does not do that. As the member from Gainsford very clearly set out, it sets out which places of law should be supreme. And that, to me, is a different argument to whether or not there are laws protecting your rights. So let's be very clear. We're not talking about a Bill of Rights that is a Bill of Rights. We're talking about a bill of clarity about where rights rest and who gets the right to interpret them. I also wish to disappoint the member from Gainsford. We are still part of the European Court of Human Rights. We might have left the European Union, but the European Court of Human Rights does still apply in the UK. And some of us agree with Winston Churchill that that was quite a good thing and think we probably should uphold that. Indeed, I believe that's still the government's current view. So let's also put to bed the idea that in passing a Bill of Rights, or a bill clarifying where rights are being determined, that would somehow mean that a particular right would be subject to judge intervention and other rights wouldn't. All the rights set out in this piece of legislation would be subject to the courts. Justice is freedom of speech, justice is the rights of those people seeking asylum in our country. Abortion would be no different in this legislation. It would simply be another right where we would be clarifying where the balance of rights are. Absolutely, absolutely.
Thank you, Chair. Would the honourable member agree that there would be very little disagreement with the right to protect freedom of speech? There'd be the right to protect freedom of expression or freedom of religion, practice whatever you want. Would she agree, therefore, that the subject of abortion is much more nuanced, and there are some people who would never take away a woman's right for an abortion, but it's not a black and white issue, and therefore it cannot be compared with the right to freedom of speech, freedom of expression, freedom of religion. It simply cannot be compared with that.
So, I disagree with the Honourable Lady, and I would invite her to talk to campaigners in my community, for example, who feel very passionately about where the line about a right to religious freedom is drawn and the right to freedom of speech. These are not uncontested subjects. We all passionately believe that human rights are important, but how they are applied and what they mean in practice can often be a very different thing. And I would also argue that a woman's right to choose, and multiple public opinion surveys back this up now, is something the majority of people in this country believe should be a right for women, because right now it's not a right for women. A woman doesn't have a right to choose to have an abortion. We need to be very clear about that in this country, because that's where this debate is coming from. It's also where I agree with the member for Gainsborough when he says that this should be a parliamentary matter. That is exactly what this petition is calling us to do, and indeed what those conversations about whether or not the bill should include that. And I simply say to him, I don't know who he means to be a hijacker in this place, but I've always never believed that the role of opposition is to sit on the sidelines for 5 years cheering on the government's work. It's to look to make progress on the issues and concerns that you are concerned about. And if we can make progress on this very issue, I'll wager it will make a difference in many ways that he hasn't yet realised, because we don't have a right to an abortion. Even those women seeking abortions do not have a right to an abortion. They have to secure the support of 2 doctors, and those doctors have to act in good faith to agree that a woman should have an abortion, because the alternative would require her to have mental distress or physical distress or a threat to life. That is not a right. I will happily, of course, give way.
I'm interested to see what the Honourable Lady thinks the effect will be of having a general right to abortion in statute. Not set aside the provisions of the existing statute. The judges would be constrained by statute law. They cannot set it aside. It would merely be a gesture politics.
I'm very glad that the honourable gentleman raised that question, because he can doesn't need to look far to see an exact example of actually what does happen when you have a human right to an abortion. Because let's be clear, it's women in England, Scotland and Wales in this nation state who do not have access to a right to abortion. Women in Northern Ireland do. So we have already now got legislation on our statute book that directly gives women in Northern Ireland a human right to an abortion, which means that there is...
Without an act.
Well, there wasn't. The gentleman is shouting, but I guess he missed out on the very debates we had in 2019 about this issue, where this place did indeed pass legislation. And that's a very interesting mechanism for this bill, and why this bill could be the right vehicle for this, and why a human rights perspective is important. Because those of us who believe the time has come to say abortion is healthcare and to remove the criminal element recognise that removing the criminal element requires you to replace it with an alternative foundation for those rights. And it is my argument, and those of us who believe that we should make abortion a human right in this country, that a human rights perspective should be the alternative. And we look at Northern Ireland, where that has now happened, and see it as an opportunity to learn from that. Now, let me preface my statement by saying just because we have a human right for abortion in Northern Ireland does not mean, as yet, we have satisfactory, legal, local, safe abortion services. Those who are hostile to abortion have used their position to prevent access. But what is different and what is so powerful about having that human rights approach is it's the Secretary of State who is having to drive change in Northern Ireland, because he has to defend the human rights of women in Northern Ireland as a reflection of the CEDAW protocol. I will happily give way. Can I just clarify, though, for my colleague and I'm so sorry, but his constituency evades me. You'll have to forgive me, it's only a Monday. Bolton West, I thank him. Changing the foundation of that legislation does not change the regulations about whether or not sex selection abortion would ever be legal, about the time limits. It's simply about that fundamental principle, because right now, his female constituents do not have a right to an abortion. They may be able to go and request one, but somebody else makes that decision. And in that point, I'll happily give way to his question.
I thank the Honourable Lady for giving way. I think she does clarify the point to a certain extent, but she also does highlight in that clarification that some people, women or families, do choose to have a sex-selective abortion, which is a contrast to the argument being made about it necessarily always being about healthcare. There are other factors as well.
I'll just gently say to the gentleman that if he's dealing with families where that is a possibility, prosecuting a woman who is being asked to have a sex selection abortion rather than supporting her or recognising what is not the way ahead. And the cases my colleague from Gower set out so powerfully show why decriminalisation is a very live issue, because it's the 21st century, but this country is still prosecuting women for having miscarriage. It's still threatening them with investigation for a healthcare issue. And rather than recognising what other pressures might be in their lives and supporting them, we are criminalising those women, as they did in the 1800s with the Offences Against the Person Act. And I'll wager that he would not want to be on the side of arguing that a piece of legislation which put abortion in the same level as setting fire to this place, or indeed murder, would be the right way forward. That right now, the penalty under this legislation is lifetime imprisonment. Now, there may be some people who are comfortable with that. Many of us who believe that when a woman is seeking healthcare, she deserves our support and compassion and tolerance would not be. And the question for those of us who believe that we should be equals under the law is whether the Honourable Gentleman himself would accept a situation where that basic right to decide what had happened to his body in this circumstance would be denied from him and given to two other people who could only give him that option if they agreed that he would go mad or lose his life not to have it. I would wager that he would not find that acceptable, perhaps if it was around having a vasectomy. The Honourable Gentleman wants to give way? Absolutely give way.
Thank you for giving way. And I wonder, under the new dispensation that the member is arguing for, how would the member propose to deal with, say, a very difficult case, the one which was brought to prosecution, namely that of Sarah Gatt, where you know that the judge in that case actually said that this was not involuntary manslaughter or indeed offence save murder. How would the member propose under this new dispensation actually deal with a difficult case which the law would ultimately throw up?
The Honourable Gentleman suggests that difficult cases are the unique preserve of abortion provision.
No.
There are difficult cases when it comes to freedom of speech and people's motivation. What I do recognise is that right now there are women on trial for having a miscarriage or potentially being accused of seeking an abortion, perhaps when they were further along in their pregnancy than they realised. And it is not right to see these as criminal matters when we're talking about a healthcare provision. So in which case, what we need to do is set out an alternative foundation for the law. Now, many of us recognise that this Bill of Rights is not a good piece of legislation, that the things that it does will not achieve the outcomes the government hopes, but it opens the door to a conversation about what rights women in this country should have. And if the government is determined that nobody should interfere in somebody's freedom of speech from Europe, then why does this government deny the role of protecting women's wombs from being interfered and letting women choose for themselves whether or not to have an abortion? We would not be unique in making that choice. Countless nations around the world already do it. Indeed, in the current criminal basis for our abortion access, we are behind other countries like Russia, Australia, South Africa, Vietnam, Germany and Argentina. Other countries like Canada have explicitly classified abortion as a human right. Lawmakers in France have just agreed to write it into their constitution. Belgium, Denmark, Sweden are also considering constitutional amendments. I'll just finish my sentence, if I may. I'm desperate to hear what the member from Gainsborough has to say, but I want to be very clear that this is a debate that is happening around the world. Now, Roe versus Wade was the spark that reaffirmed that that fire needed to burn, because many of us have known that even though we have access to abortion in this country, that access is not secure. It can be challenged. Indeed, I have spent 12 years in this place listening to people chipping away at that access and using the fact that it is not a legal right to do so. the member from Gainsborough and I have been on different sides of this debate. I would love to hear from him why he believes he has a right to choose for a woman what happens to her body.
I'd quite like to ask my own question, if the Honourable Lady will forgive me. If the right to abortion is so restrictive in this country, why do we have one of the highest abortion rates in the world?
I did not say that it was restrictive. I said it's patchy because it is patchy. What we understand is that those who live in rural areas find it much harder to find the 2 doctors required to secure an abortion. That one of the reasons why many of us fought for telemedicine to be able to help that process and ensure that during the pandemic women's rights were not left behind. But the member from Gainsford misses a fundamental point. A woman should be able to choose what happens to her body. And if we have a Bill of Rights, surely it sets out those most fundamental basic rights. I was coming to a close, but I'll happily take his question.
The answer to the question that she asked, my honourable friend, is the reason we take this caveat to an absolute right is because there has to be a balance of rights, and there is another life involved in this question of abortion. And that's why we constrain it by the proper means of parliamentary legislation, rather than handing that decision to an unaccountable judge.
On this side, I hope to hand that decision to a very accountable woman, because I trust women to make the right choices for their own bodies. And when the member opposite talks about we, I hope that he's not talking about men, because actually there are men and women across this country, the majority, who recognise that we should trust each other to make these very difficult, sensitive decisions and not deny women that basic human right. To clarify again, if he wishes to go and look at Northern Ireland, because I suspect from what he says he hasn't yet, adding a human rights foundation does not remove any of the regulations around time limits, any of the importance about medical professionals, any of the safety requirements, or indeed introduce sex selection. What it does is it sets a foundation which is based in healthcare, not criminal legislation, and it sets a foundation, crucially for many of us, in equality. Because I would venture the member opposite, were we to say that he would not have basic bodily autonomy, would be equally as furious and concerned about what that means for him as it does for women. Yeah. Now, the previous Justice Secretary and the current Justice Secretary have all argued that we don't need to include this in this bill because that right is settled. The members opposite have just shown that it's not settled, actually. This is a very live debate. So it is absolutely right that Parliament has an opportunity and our constituents have an opportunity to lobby us, to look for where we can make progress. The decision to overturn Roe versus Wade caused those shockwaves, but it also highlighted that that right was written in liberty and privacy. It wasn't written in a basic human right. This would write it in as a basic human right. And for many of us who do not agree with the government's piece of legislation, we will not be deterred, nevertheless, from seeing and how we can make progress to defend and uphold those rights. Because what Roe versus Wade teaches us is that we cannot be complacent. And indeed, when I see a government that chose to remove a commitment to the human rights of women around the developing world to access sexual and reproductive services as part of an international conference, I know that that concern is merited. So I ask the Minister if he will clarify why is the source good for the goose but not for the gander? Why is it that we have a piece of legislation that will set the limits on interference in free speech, on deportations, but the government somehow says that it would be wrong for the courts to be involved in upholding a woman's right to choose? These arguments do not make any sense, but they reflect the fact that it is time that this House... All right, one more time and I am going to...
She's making a powerful speech, even though I fundamentally disagree with most of the points she's making. But just for clarity, could the Honourable Lady explain at what point she feels the unborn child gains human rights? Is it at 16 weeks, 24 weeks, 28 weeks, or never until it is actually born?
I recognise the point that the gentleman is trying to tempt me into. I have no problem with our existing legislation, except the fact that it is rooted in a criminal foundation. So for me, decriminalisation is absolutely of paramount importance and urgency. My point is simply when you remove the criminal foundation from which all abortion legislation follows, you create a lacuna. I am arguing that entering human rights into that lacuna, as we have in Northern Ireland, is the right thing to do. Because I wish for my constituents in Walthamstow to have the same rights as women in Belfast, and right now they do not. And this bill and this petition, I would wager, is about the 21st century and how those rights are exercised. That does not mean that we would not have controls on how you access abortion, that there would not be a right discussion about time limits. But it means it would come from a position not where there would be criminal prosecutions, indeed not just of the women, but of the doctors and medical people involved. It would come from a perspective that it is a healthcare issue. We do not have these debates when it comes to vasectomies. We do not have these debates when it comes to ankle injuries. And yet somehow when it comes to a woman's body, we have determined, as the member opposite has said, that Parliament should be involved. Well,
One very last time.
One last time, I really do want to finish. I'm sorry.
I thank the Honourable lady for giving way. Does she really compare the procedures of a vasectomy with an abortion? Does she see them as of equal and like standing when one involves, as has been described by others, a second life? And she herself has said that she recognises that there is a point at which, during a pregnancy, where those rights are conferred on the unborn.
I would say to the member opposite, turn her question round. Why does she believe that it's acceptable for men to be able to choose to have a vasectomy, but a woman cannot choose what happens to her own body? Why do we deny women choice over their bodies, but we don't deny men? And forgive me, but I did do biology at school, so I know that there are often two people involved in the creation of a baby. So surely we should hold men equally accountable, yet somehow we don't deny men the rights to their bodies and bodily autonomy. I want to come to a finish, Sir Graham, because I know there are other people who have different views to me who wish to make their point. My point is simply thus: to argue that the Bill of Rights is the wrong vehicle is to miss the point, because this right does not exist for women across Scotland, Wales and England as yet. It does exist in Northern Ireland. And if we trust women in Northern Ireland, we should trust women in England, Scotland and Wales. And if we recognise a human right in one part of the United Kingdom, surely we should recognise it in all. Now, I do not wish to be called a hijacker. I think that is slightly disrespectful of the important point of parliamentary democracy. I recognise there are people here who will never agree with a woman's right to choose, and I believe they should be honest about that, because it wouldn't matter whether it was a Bill of Rights, this Bill of Rights or any piece of legislation, they would not support it. But for those of us who do support women, who do recognise that the case for decriminalisation is long overdue, we have a responsibility to set out what comes next. I believe it is a human rights proposal. I believe that all of our constituents would benefit from that perspective and that approach to a healthcare issue. And I hope when the Minister stands, as I say, he will clarify why this piece of legislation is acceptable for some freedoms, for some rights, and whether the government doesn't believe that a woman has a right to an abortion. Because if she does have a right to choose an abortion, they need to legislate for it. Thank you. Mr. Sen.
Maria Miller.
Thank you, Graham, and it's a great pleasure to serve under your chairmanship. And can I start by commending the Honourable Member for Gower for the way in which she set the debate out. It's a difficult thing to do from the Petitions Committee, and I think she did an excellent job. I very much welcome this debate, because legal access to abortion needs to be looked at in this place. And I think the debate today has demonstrated the pent-up demand to have a clear plan and a clear way forward. But I'd like to add perhaps a different perspective, which maybe Sir Graham does demonstrate that there is a real need for this to be looked at in some more detail, because I'm yet to be convinced that the change that's needed is by enshrining this into the Bill of Rights. Probably because I think this is far more complicated than that would allow. But change is needed, and I'd like to commend the petitioners for giving us the opportunity to bring this forward today. And I hope the government takes away this debate, not just as a 3 hours sitting in Westminster Hall hearing people who've got a lot of conflicting views, but the real cry for help that we need a government who is prepared to put its head above the parapet and come forward with a plan of action on this. because change is needed. I believe that change needs to be decriminalisation, but I don't believe it necessarily needs to be through a Bill of Rights. And the debate today is driven, I believe, by the real frustration, not just by people in this room, but by the many people that did also support a number of the other measures that the Honourable Lady who's just spoken has brought forward. Yes, in a slightly haphazard way, but she's had no choice because there hasn't been a way of doing it more coherently. Our abortion law is completely out of date. UK access to abortion is an exemption from prosecution under criminal law, which is well behind other countries in the world. And I think honourable members and right honourable members speaking need to acknowledge that. Our legislation is out of date. It's governed by offences which date back to the 18th century and need urgent change because criminalising abortions abortions are criminalised in a way that no other healthcare provision is. The 1967 Act gave a very limited number of exemptions and, other than that, the law outdates or predates even when women were able to sit for election to this place. So, of course I will.
Thank you very much. I thank the Honourable Member way she mentions the 1967 Act. I know from what my mother told me at the time, because I was actually too young to know about it, but that Act sparked a huge feeling of social revolution almost in this country and in the rights of women, that many women now feel are actually under threat. And while Roe versus Wade may have happened in the United States, the sentiment that it reflects is something which women in this country feel very strongly is a threat to their rights. So in decriminalising abortion and including it in the Bill of Rights, one or the other perhaps, we would be re-establishing that social change and that revolution in women's position in society.
Can I thank the Honourable Lady for her intervention? And I think she's right to say it could be one or the other. But at the moment, we have no clear path to understand how and when we're going to have that discussion. And I pick up one other point relating to the 1967 Act, which is too often when this issue is raised, we're told these are issues that are brought up by backbenchers. And indeed, the Honourable Lady who spoke has done that on many occasions, has brought up issues from the backbenches. But that's left us with an incredibly piecemeal approach to reform in this area. And I do hope that my right honourable friend, the Minister, does not say this is a matter for backbenchers, because it no longer is, for the reasons that the Honourable Lady who just intervened on me has said. This is a very complicated issue and it needs dealing with by government in a comprehensive way. Because I believe, as a result of a phenomenal change in the way women access abortion in this country, the law is now lagging well behind the reality for most of our constituents. 87% of abortions are now medical abortions. They are not surgical. They are completely different to when this law was put in place. Now, you may agree with that, you may disagree with that, but the way the law regulates it is completely inconsistent with the reality of the medical procedures. So before I believe, even contemplating enshrining abortion as a right in the Bill of Rights, which may or may not be the right thing to do, we need to completely relook our approach to the way it is dealt with in the law. Why, as somebody's already said in this debate, since 2015, 52 women have been reported to the police under the abortion law. Now, the Honourable Gentleman, I think, said 800,000 births a year. But if you're one of those 52 women who have been reported to the police for a procedure that you thought was a medical procedure, that is something which I think will be quite shocking to many of the people that we represent to understand. And yes, only 17 of those women have been subject to criminal investigations. But how many other medical procedures have been subject to criminal investigations? I think not many, Sir Graham. The Women and Equality Select Committee, when I chaired it, did an inquiry into abortion in Northern Ireland, which identified the chilling effect that the law has on medical practice in some circumstances, leaving vulnerable women without the help that they needed. And I pay tribute to the Honourable Lady for Walthamstow, for really building on that and bringing forward measures which we were able to, in a piecemeal way, change the situation for that particular group of women. Now, I understand why the situation in the US has excited extreme concern in this country. The Supreme Court ruling was extremely worrying, and there will be much being done on the other side of the Atlantic to discuss that. And I can understand why that would trigger a debate today. But if the motivation is to put abortion on a firmer footing, I think we need to really carefully consider a different approach than just attaching it to the Bill of Rights, which I think may not give us the opportunity to discuss it in the depth that we need to. So as well as listening to the very principled views of individuals here, colleagues here today, I think we also need to listen to medical practitioners. The British Medical BMA is very clear that abortion should be regulated in the same way as other clinical procedures, which are already subject to an extensive range of professional standards, regulations, criminal and civil laws. And rather than criminalising women, we need to make sure that we have the right medical help in place and that they aren't afraid of accessing it. And I fear that debates like this today could unintentionally create more fear amongst those who do need to, for whatever reason, access abortions. I absolutely defend the right of honourable members and right honourable members to completely disagree with the idea of choosing an abortion, but every woman in this country must have that right to make for themselves. That is the country we live in today. There's no need for that to be in a Bill of Rights, I believe, in the same way as there's no need to put other medical procedures into a Bill of Rights. Changing the basic law is something which has the overwhelming support of the Royal College of GPs, the Royal College of Obstetricians, the Royal College of Midwives and the BMA. So why do we put our views ahead of those of medical professionals on this issue and no others? I believe, Sir Graham, that we have made real progress in this place in a piecemeal way. And I think people fail to see the level of support for buffer zones when that amendment went through the House. I fear that perhaps the voices in this debate today are not entirely representative of our broader group of colleagues, because not only have we seen buffer zones agreed to, we've seen telemedicine agreed to, we've seen decriminalisation in Northern Ireland agreed to. So let us just be really careful, and perhaps the Minister needs to be really careful that he does sense the proper mood of the House when he's considering these issues, because I think that sometimes these smaller debates perhaps don't reflect that. Sorry, somebody was trying to get my attention. No, okay. I ask in closing, Chair, that the Minister perhaps gives us a little bit more light on what the government is planning in this area. It is clear they don't see this as an issue in the Bill of Rights, but what is going to be done instead? When I probed the, I think, previous but one Health Secretary on this issue during departmental questions, I then received a written answer back to my question clarifying that there is a sexual and reproductive health action plan which is currently being drafted by the department. And I was assured in a letter in August that abortion was going to be part of that. So perhaps the Minister might want to update members who are present in this debate today what the progress is there, because we don't need another set of piecemeal proposals. We need a government who's going to grasp this difficult issue and put together a proper plan so that we can have something which our constituents would seem not only reflects their experience of this very difficult area, but also heeds the very clear concerns of the medical profession.
Chair.
Thank you, Honourable Member for Gar for setting the scene. Although I have to say, in all honesty, the Honourable Lady and I have two very, very different points of view. But Honourable Lady, I respect the Honourable Lady's right to have that point of view. I hope she will respect my right to have a different point of view, and I wish to put that forward today if I can. Always a pleasure to see the Justice Minister in his place, a Minister who I hold in high regard. We all do, I think, to be fair. And I look forward very much to his comments and also to the
those right honourable members who will make their views known on an issue. I don't think there's been a debate on abortion in my time in this House that I haven't had made the effort to speak on and express the views on behalf of my constituents. I think, with respect to the Honourable Lady, she referred to Northern Ireland. My understanding very clearly in the polls is in Northern Ireland that the majority of people are absolutely opposed to abortion on demand and the system of abortion that there is in Northern Ireland at this present time. That was imposed by this House, and we'll refer to that, of course. But I just want to put it on record that that's the case. I've received literally hundreds of emails, as I know others have, on this debate from my constituents of all ages and both genders, from all political opinions and from all religious persuasions, on the importance of speaking up for life, and furthermore, the point of speaking up for both lives of the woman and the unborn child. These debates always seem to focus, for some anyway, on the rights of the woman, but the rights of the unborn child are disregarded as if they didn't matter. I want to put on record my position, Mr. Chairman, which is to protect the lives of both the ladies and the unborn child. I'm going to refer to that later on as well. So there will always be a voice for the unborn child. I believe totally in the right of life, and thank the organisation The Right to Life for their help in preparing evidentially for this debate today, and some of the things that they've made me aware of. So I will continue to do this. This is the right thing to do. I'd like to address an important point that often gets misunderstood in this debate. It's fundamental to what we're talking about. There's no right to abortion in international law. The House has come under intense pressure to change the UK's abortion laws so that they conform by international law. But let me be clear, let us all be clear. The European Convention on Human Rights does not recognise a right to abortion. The UK is under no obligation, I think the Honourable Member in the interventions referred to that, to change its law to conform to international law. Don't take my word for it, of course. Look at the evidential base. The European Court of Human Rights has confirmed there is no right to abortion in international law. It has maintained this position for over the last 30 plus years. The USA, and others have referred to it, shouldn't and can't influence the law in the UK. So I'm glad to say that the UK retains its own jurisdiction to make its own laws, and there's no need nor demand to change those laws to recognise a right to abortion. Furthermore, we in Northern Ireland have the jurisdiction to make our own laws, at least we have on most occasions, but on other occasions we don't have, because other members think it's better that they should make a decision here rather than the elected representatives back home in Northern Ireland. As my party's spokesperson for health, I will get across the point on behalf of not just my constituents, but all those in Northern Ireland, the vast majority who feel that their democracy has been overruled. The decision was able to be made in Scotland and Wales and here in England, but somehow not in Northern Ireland. So I want to speak for women in my constituency in Northern Ireland who oppose the abortion, and they do not agree with the legislation that's been imposed by Westminster upon us. So in that question, I asked the Minister, being the Justice Minister, just why and how should it be right that legislation should be passed here to the disrespect and to the animosity and the opposition of those in Northern Ireland. I make this comment because it was in the paper last week. The Secretary of State for Northern Ireland, I know he couldn't maybe just find the right way of making sure that all the monetary monies for energy price increases would be made available in Northern Ireland. He could find, guess what, the money to finance the abortion for Northern Ireland. So, I asked that question with great respect to the Secretary of State. Just how can he do one thing and not do another? With the recent introduction of the Northern Ireland Executive Formation Act 2019 and the Abortion Northern Ireland Regulations of 2020, women are now able to obtain abortions in Northern Ireland. Abortion is available de facto on demand for 24 weeks gestation. I know that was opposed by us in this House and by others, by the way, many of who are here tonight and many others who aren't here. I find this shocking, but also very, very saddening. I have a constituent who had her daughter at 26 weeks of age. I've met that lady. I think others have referred to it When she was born, she could fit in her daddy's hand, that palm of hand. That's how big that wee morsel was. But that lady today is a full-grown lady. Grown up, has a job, drives and lives happily as anyone else will do. She's alive today because of the NHS, of the system we have, and many years past, a premature baby would not have lived. But the point I'm making is that if she, at 26 weeks born, can survive, then why is there terminations available from 24 weeks? To allow on-demand abortions up to 24 weeks just does not give the baby a right to life. 100,000 people in Northern Ireland are alive today because abortion was not available in Northern Ireland. 100,000 people who have made a significant contribution to society, who have been married, who have jobs, who have a positive attitude to life because of that, are alive today. So again, what has happened to us in Northern Ireland, I believe, is something that's totally outrageous. Many on the other side of the debate, particularly those who take a more globalist view, for want of a better description, try to claim a right to abortion in international law. But the European Court of Human Rights has been crystal clear. Its decisions confirm that Article 8 of the European Convention on Human Rights, the right to private and family life, does not confer a right to abortion. And the Court has also ruled that countries can pass laws that ban or restrict abortion, even where the health and well-being of the woman are at risk. Such laws would and could not offend Article 8. There's a claim that the public and medical professionals overwhelmingly support decriminalisation. This is simply not the case. Evidential, it says 91% of women agree that sex-selective abortion should be explicitly banned by the law. And the Royal College of Midwives' support for the BPAS, abortion up to birth, campaign saw a backlash from over 1,000 midwives who protested the RCN position and national opposition. The Honourable Gentleman for Bolton West, in his 2 interventions earlier on, referred to this very case of sex-selective abortions. And he shares, and I share, the same concern over that as a potential for the future, and how that would impact as well. Very sensitive subject, Sir Graham, with many strong and emotive views. One issue I'd like to put on record is the matter with coerced abortions from their home and the issue of easy access abortion pills. The Honourable Lady for Congleton, the Honourable Lady for Upper Band and others in this House expressed concern directly to the Minister. We met on a number of occasions to activate that point of view. This became more notable throughout the pandemic too, where women were subject to phone calls to discuss their options and send pills, often without requesting them and usually under duress. And that was our concern, always was, that it's been used maliciously and wrongly. So no face-to-face discussion or assessment, a step backward, not forward. To conclude, Sir Graham, it was not and should never have been the position of Westminster to take any decision on abortion for the Northern Ireland Assembly and for my constituents in Strangford, who overwhelmingly oppose this legislation, this change, who didn't want to see the abortion on demand that we have in Northern Ireland, who wanted to clearly stand for the right to life for the unborn child. This must be an element of respect. Respect for the thousands of my constituents who say they do not want abortion on demand up to 24 weeks. And I, for one, and many others, I'm glad to say in this debate today, will stand up on every given occasion and speak up for those constituents and, furthermore, the life of the unborn child. I will also speak up for the constitutional value of Northern Ireland within this United Kingdom and its place as a legislative body where any decisions on abortion should have been taken place in any case. Thank you, Mr. Chairman, for that, and I look very much forward to the Justice Minister's response. Ever mindful, let's protect the woman and the unborn child equally, and not to the detriment of one as against the other, which is what some are putting forward in this chamber today.
Leader Bruce.
Thank you, Sir Graham. Pleasure to serve under your chairmanship, and indeed always to follow the honourable member for Strangford. And I do want to thank the Honourable Lady Member for Gow for the gracious tone in which she introduced this debate, so right on such a sensitive issue. It is encouraging to note how many colleagues are here today expressing concern about the wording of this petition, and I join them. The idea of a right to abortion not only conflicts with the established position of international law on the right to life, but would also cause huge complications for our domestic law. Including abortion in a Bill of Human Rights is inappropriate and likely to result in extensive litigation to establish the extent of such a right. This petition is, whatever our views on abortion, therefore from a legal perspective misguided, and I agree with the response of the former Justice Secretary when he said there is no strong case for change. I'd just like to refer to one point made by the proposer of the debate. When the Honourable Lady referred to just one woman bringing forward this petition, and it's true that the petition has been brought in the name of one person, but let's be under no illusion here. This is part, the move to create abortion as classified as a human right, is part of a very well-coordinated national and international campaign to have abortion declared as a human right. So I'd like to start, if I may, firstly, to comment from the international perspective on this and to say a few points about the robust protection of the right to life in international law and the explicit rejection of the so-called right to abortion. And it's important for us to start with this perspective because we've heard it said that the UK must adopt more expansive abortion laws because of international law. But why should we? We are not under any obligation to liberalise abortion laws from international legal texts. None of the 9 core treaties that the UN recognises have recognised abortion as a human right. Human rights are, by common definition, inherent or inalienable rights or freedoms afforded to every person without discrimination. They must be upheld and protected by governments, and I'm sure that any new Bill of Rights in this country will seek to robustly uphold those fundamental rights. But international texts on human rights have never included abortion. Allow me to reference this with 4 points. Firstly, the International Covenant on Civil and Political Rights affirms the inherent right to life. It contains a provision to explicitly protect the life of a pregnant woman, which in the preparatory text is explained as, actually I should say, in the travaux préparatoires, I think I've nearly got the French right, the preparatory text is explained as, to quote, to save the life of an innocent unborn child. Secondly, the Declaration of the Rights of the Child states, the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection, before as well as after birth. The need for such special safeguards have been recognised in the Universal Declaration of Human Rights. Now that quote from the Declaration of the Rights of the Child was confirmed by the Convention on the Rights of the Child, and the UK has ratified all 3 of those treaties. Indeed, the preamble to the Convention of the Rights of the Child was very much indicated that it was an impetus behind our landmark Children Act in 1989. And under that convention, all countries are obligated to ensure to the maximum extent possible the survival and development of the child, including the unborn child. Yes.
I've been listening to both sides here, and I'm not hearing an answer to one question which seems to me fundamental, and that is, at what point does a fertilized egg become a viable human being with rights? And from one side, I'm not hearing any recognition that a baby about to be born is actually viable and has got rights, and on the other side, I'm not hearing that a newly fertilized egg is not yet a viable human being and therefore does not have the same rights as a human being. And it's going to be a dialogue of the deaf until both sides recognise that this is a spectrum and it's not an either-or.
Well, that is a discussion which has been ongoing for a long time, and many in this room hold different views on that subject. I happen to believe myself that life begins at conception, but I know that others take a different view. The third point, the Convention on the Elimination of Discrimination Against Women, CEDAW, also doesn't advance any concept on a right to abortion. Nowhere within the text does it reference terms such as reproductive rights, pregnancy termination or abortion. Instead, it requires states to provide suitable care and services for women during pregnancy. And fourthly, the former UN Special Rapporteur for Health has told the UN General Assembly that there is no international law on the matter of abortion. I think it's also important for us to note that the European Court of Human Rights has never ruled that countries within the Council of Europe need to consider abortion as a human right, even though it has considered the matter several times over the past 20 years. 3 points are relevant here. The ECHR has affirmed that Article 8 of the European Convention on Human Rights, the right to a private and family life, cannot be interpreted as conferring a right to abortion. And I'll quote from a 2010 case, "The woman's right to respect for her private life must be weighed against other competing rights and freedoms, including those of the unborn child." Secondly, the ECHR has ruled that forced abortions are a breach of Article 3, the prohibition on torture, noting that forced abortions can have, quote, long-lasting negative physical and psychological effects, end of quote, on women. And thirdly, the court has reaffirmed that there is no actual right to abortion, even in the, and I accept the tragic case of rape. The UK really is under no pressure from the UN or from the European Court of Human Rights to reform its abortion law by classifying abortion as a human right. I'd now like to turn to consider this issue from the domestic perspective, if I may, and I know we've already had a lengthy discussion on this during the debate here today. But I would like us to acknowledge that if we include abortion as a right, as a human right, how chaotic that would make our laws here. We've already had the discussion, and there are different views on this, as to what a right to abortion would do in terms of, would it equate to decriminalisation of abortion wholesale? Would it create an absolute right to abortion? Could it mean the removal of gestational limits, allowing abortion up to birth? Could it mean abortion based on the gender of the fetus? Could it mean the removal of medical safeguards, including the involvement of doctors? Would it mean the erosion of the conscience rights for medical professions? All of these questions would be thrown up. Yes.
I genuinely thank the Honourable Lady for giving way, and because one of the things I try to grapple with is that, you know, knowing how women feel. And when I was on the Women Inequalities Committee, and the Honourable Lady from, Right Honourable Lady from Basingstoke knows this because she was the chair, to listen to those women, does the Honourable Member really believe that these women should be criminalised?
Absolutely have the utmost compassion with any woman put in the position of having to make a decision about abortion. And I hope that nothing that I've ever said in all the years in this House, when I have stood as the chair and now co-chair for the pro-life group, has ever given that impression. I would never want to do that. But this proposal risks entirely removing safeguards in our country which relate to abortion and which I believe are right and proper. Yes.
Yeah. Can I thank my honourable friend for giving way? And she's making an important case that she believes has a great deal of strength in terms of this not being viewed as part of a human rights argument. But does she not share my concern that every single Royal College of doctors, experts in this area, want to see a change in the law? Does she not think that even if it's not possible to do it through the Bill of Rights, that some other piece of government work is needed to make sure the law is fit for purpose? Or does she think they're all wrong?
Well, it's very interesting that there are a great number of organisations, as the Honourable Lady has mentioned, or Right Honourable Lady, who are joining together in what I have referred to earlier as a a national and indeed international campaign to see the law changed on abortion. And I do believe it is all part of a coordinated move to reduce the protection that already exists in our country today for the unborn child. Yes, I'll give way.
Thank the Honourable Lady for giving way, and I fully support what the Honourable Lady is saying. In my contribution, I referred to the Royal College of Midwives. I referred to 1,000 midwives who expressed concern about the way the direction we're going. What it has done is divided opinion. Of those who are in favour of abortion and those who are against. And quite clearly, this cannot be driven forward when we have a division amongst the people the doctors and the nurses and themselves.
I'll remember for that intervention. In this country, we do already allow abortions to term where the unborn child has relatively minor and correctable physical conditions. And I've spoken about this many times in the House before because I have a son who was born with a club foot. 90% of babies with Down syndrome are aborted. A right to abortion would open the door to even more abortions after 24 weeks, a period of time inconsistent, as we've heard, with medical advances which enable babies prematurely born before this now to survive. Now acknowledged as 22 and in some cases even 21 weeks. Yes.
I think she's inadvertently now, notwithstanding her principled view, which I respect, that life begins at conception, but she has now addressed the question that my honourable friend from New Forest East asked. When do those rights come to the child? And it's on the basis of viability outside the womb. Whether we've got the answer, the correct dates right or not, I don't know. But nevertheless, that is the answer to his question.
Well, I thank the Honourable Member, or Right Honourable Member, for that intervention. And indeed, I'm relieved that it is for this House to make a decision on when we review those weeks. And I'm hopeful that we will continue to be in a position to do so for a long time to come. That is an issue which we now need to look at again and see a reduction from the number of weeks from 24. We know that late-term abortions are unsafe for women. We know that most European countries have abortion gestation limits of half of ours, 12 to 14, and research shows that late-term abortions are distressing. And finally, polling shows that women don't want a time limit increase. All of this would be thrown into the mix if abortion is classed as a human right. In conclusion, there are many other things I could say against this petition, but I would just like to ask the House a simple question. What type of society do we want to create for our country? Surely is it one which promotes a culture that upholds and respects life, including unborn life. I am so grateful to live in an age where I know that there is science behind me, science that tells us that a beating heart can be detected at 6 weeks gestation, that the ability to feel pain can be evidenced from as early as 12 weeks, and that the sucking of thumbs can be seen at 15 weeks. I stand for the rights of the unborn because it is undeniable that they have life. As the campaign slogan states, both lives matter. Let's develop laws that protect the life of the unborn child more, alongside the lives of women.
Thank you. Alex Davis-Jones.
Thank you, Chair. It is a privilege to speak in this debate today, a debate which we greatly need and is quite timely. I would like to put on record my thanks to my good friend, the Honourable Member for Gower, in the tone in which he has led this debate. It is incredibly important and powerful, and she's done that with a great deal of respect and dignity. I'd also like to thank Caitlin, our petitioner, and everyone who signed this petition in bringing forward this debate today. But Chair, you'll be pleased to know that I will keep my comments brief, mostly because I've spoken about the need to keep abortion services available for all women at length on many occasions before. Let's be clear, abortion is a basic healthcare right that must be available to all who seek it. We are extremely fortunate in this country to have an incredible NHS at the heart of our communities, and while it may be under severe strain at the moment, and that is definitely a debate for another day, it is incredibly important that services like abortion remain properly funded and are fully accessible. Because we only have to turn our eye to what is happening across the world, as others have said, particularly in the United States of America and in Poland, to see how easily the fundamental right of what essentially is healthcare can be rapidly dismantled. However, we must also acknowledge that abortion is extremely sensitive and is an incredibly emotive issue that engenders passion views on both sides. It is absolutely vital, Chair, that anyone considering an abortion receives impartial, non-directive and clinical information on pregnancy in order to make an informed choice. And that is why I share the concerns of many, many signatories of this e-petition that we are considering today. As the government considers its position on all of our civil liberties in the Bill of Rights, they must consider whether abortion rights in this legislation are appropriate. Now, we all know the many reasons as to why an abortion might be sought. I don't need to list them for members today. But we must also remind ourselves that behind every abortion is a woman with a story, often a complicated one at that, and a woman with a choice. And it is that choice that we are seeking to protect. That is why we cannot bring politics or judgment of any kind into decisions over healthcare availability. Like colleagues from across the House, I am keen to hear from the Minister about his plans to enshrine abortion rights in UK law, and if the government does decide not to bring forward this bill, then where would be the best legislative fit for us to do this? We've discussed today about how the need for this to happen. If this bill is not the appropriate place, can the Minister clarify in his remarks where exactly members, hijackers, would be best placed to settle this once and for all? Because we do need to push for change. I'd also like to push the Minister on discussions with his Cabinet colleagues in the Health Department on when we can expect the Women's Healthcare Strategy, because that is absolutely vital to this as well, to ensure that women have access to safe abortions. But we are in a very, very sad position, Chair, to be having our rights placed on the statute book at all in order for them to be valid. It shouldn't have to be this way, and I wish abortion was an option readily available to everyone, everywhere, who is seeking support, no matter their circumstances. So I hope the Minister can alleviate my concerns today. I look forward to working constructively with him and other members across the House to ensure that abortion remains a top healthcare priority for this government, and so that it remains a human right and all women are protected and ensured access to safe abortion.
Thank you, Senator Charles. It's a pleasure to serve under your chairmanship. It is clear that the other side in this debate will want to make it seem like the woman's right to choose is under threat and perhaps even becoming increasingly difficult. But the reality, when you look at the evidence, is that you will find that it has never been easier to access an abortion in this country, particularly after the decision to allow medical abortions to happen at home. According to the Times, 1 in 4 pregnancies in Great Britain end in abortion, with last year 214,000 terminations being carried out in England and Wales, the highest number since records began, nearly half of which were repeat abortions as well. Those who wish to essentially decriminalise abortion often make the claim that they have overwhelming public support in their favour, particularly from women. But when you look at the evidence, it does not bear this out. In fact, it points in totally the opposite direction. Removing all legal restrictions would risk opening the door to late-term abortions on demand right up until birth and for any reason whatsoever. Polling from Savanta.com-Res paints a clear picture on how out of step this is with public opinion. Only 1% of women wanted the 24-week gestational time limit to be extended, whilst 70% of women favour the reduction in time limits. Absolutely.
In talking about decriminalisation, we have a model in Northern Ireland now which brings that idea into practice. Does he have any evidence that there are end-of-term abortions happening in Northern Ireland? Because I'm not aware of that. It appears to be a way of shaping our law in a modern way rather than a way that replicates Victorian times.
I thank the Honourable Lady for her intervention. I think the point I was trying to make was the fact that in practice decriminalisation means there would be no specific law regulating abortion up until birth, and I think that is the problem we are grappling with here. If the Honourable Lady would forgive me, I'll make some progress. I think she spoke for just over 20 minutes, so I will take an intervention at a later point. This is hardly surprising given the fact that the EU medium time limit is 12 weeks. Since the point at which a baby is viable outside the womb is now closer to 22 weeks, far from discarding our time limits, it is clear that we should look to reduce them.
I'd like to briefly turn to sex selective abortion, a point my honourable friend from Bolton West has already alluded to. Unfortunately, there is growing evidence of first-hand testimony from women who have been coerced into obtaining a sex-selective abortion in this country by their partner or family, and the fact that this is disproportionately targeting baby girls. As regressive as this may seem, sex-selective abortion would become entirely permissible under the decriminalisation that some would like to see. We must think about the message this sends out to women and girls, the chief victims of this absolutely abhorrent practice. Allowing sex-selective abortion does not empower or advance women's rights. We need to show girls that we will not allow sex-selective discrimination because they contribute and are valued by society every bit as much as boys. I'll give way.
I thank the honourable gentleman for giving way, and on the point of that he is making, these women that have been coerced into having abortions, would he criminalise them?
Thank the honourable lady for giving way. I think she's merging two very different things here. Again, I'll reiterate, the point I was making is that decriminalisation effectively allows abortion up until any point. If the honourable lady would forgive me, I'll make some progress.
Regulations 2020 set out incredibly clearly what the requirements are. It is a point of...
Not a point of order, Mr Bentham.
Thank you, Sir Charles. Additionally, decriminalisation risks paving the way for abortion on request for a baby that has a minor disability or a particular genetic trait, a point my honourable friend from Congleton has just alluded to. Abortion for babies with disabilities is already present within our society, sadly. We have seen babies aborted because they have minor conditions, such as a club foot, even though these can easily be corrected through surgery. This is clear discrimination on the basis of disability, as brave campaigners such as Heidi Croter have shown in the past. Babies with disabilities will grow up to contribute and enrich our society. They simply must be treated and valued equally and the same as everybody else. With this and everything else I have mentioned, removing the few existing safeguards to the law which decriminalisation would do, would send a signal to society that discrimination against babies with disabilities and sex-selective abortion is morally acceptable. This petition is simply not a serious proposal, and as the polling shows, its goals are not supported by the general population, and especially the women of this country. The evidence shows that they want more sensible and humane limits to abortion that respect the fundamental dignity and equality each human being has, regardless of their characteristics.
Thank you, Sir Charles, for calling me in this debate. I too thank the mover of the petition for the way in which she introduced it. It was very difficult. I think it was obvious to most who saw that not maybe everything in the petition was something which the member agreed with, and that does place a person in a difficult circumstance when they're introducing a petition in this place. But I thank her nonetheless for the gracious way in which it was introduced. This debate, Sir Charles, is about the right to abortion being uniquely enshrined in law in the United Kingdom via a Bill of Rights. So uniquely that something that is allowed to destroy, not protect, should be brought onto the Bill of Rights. I think we need to see that in the light of it, because normally we bring in laws that are on a positive framework, and a declaratorily positive framework. This is about something which is actually on a negative framework. And I say that with all true compassion, because, like those in the House, no one wants to see a situation where a woman feels she has to have, or is in a situation where abortion is her only way out. But to have something enshrined in a Bill of Rights, and to frame it in that new constitutional dispensation, I think would be totally abhorrent to how law should be made in the United Kingdom. Many of my constituents who have spoken to me about this in advance of this debate see this as fundamentally wrong, and indeed many have expressed that it's a fundamentally evil way in which to create law over this issue of life, because it is such a fraught matter. And I think that it is important that that point of view is listened to. Many have talked about the international legal position. Of course, the European Convention of Human Rights, which at best will probably be the main template from which a UK Bill of Rights, if it is ever drawn up, will probably be based upon. Of course, the European Convention of Human Rights does not enshrine the right to an abortion or the right to give an abortion. It doesn't touch on that matter at all, for the very obvious reasons I think that I've already stated, that it is not their place to do it. This is a matter of domestic law, and indeed the rights that many people on a different side of the argument are seeking to protect, I would go so far to say that those rights are stronger under our British constitutional system of domestic law, rather than having a rights-based type of law on this particular matter. This debate has also been shrouded from time to time, not in this chamber I might add, but outside of this chamber and arriving to this petition, has been shrouded in misinformation. We saw the whole social media issues around it. In fact, TikTok had to take down some of the comments that were being made. So people, I think, were falsely driven to sign a petition on the basis of misinformation. Now, of course, I still think this debate would have come about. I still think it would have been something which we should not run away from. It's important that we have this debate. I agree with members for all different sorts of reasons. That's important that this debate does take place. But it should not be brought about to this House because of misinformation or by a social media campaign or a vanity project by someone who wants to have some sort of clutch to a moment of fame on this particular matter. That's not the reason why we should be doing this. We should be doing this for the right reasons. And of course, I will give way.
The whole ethos of the Petitions Committee and of the intent that the petitioner had, who was actually sitting behind you if you want to chat with her after. I genuinely think that when we had the debate on assisted dying in this place, there were accusations against groups and organisations. That is not what the Petitions Committee is about. It is not misinformation. It is where you choose to get your information from. And the fact that we are here shows that the Petitions Committee is working and that a person's voice can be heard in Parliament.
I thank the member, and I think maybe she misheard me, because I was not challenging the right to have the debate. I was challenging the misinformation that had been in social media that had encouraged people to falsely sign it. If the debate is so positive, therefore there should be no negativity behind encouraging people to actually sign it. And the word ethos is very, very interesting. Its Greek origins show that it should actually be about an ethic. It should actually be about something which has character to it, and not something which is denuded of character and of strength in that particular way. So I think the member perhaps misheard what I was getting at and the point that I was making. It does lay bare the falsehood, and indeed I will say again the naivety of bringing to this House a debate, indeed how wrong it is to bring to this House a debate or to try to shape our laws by the experiences of the American legal constitutional system. The two cannot, if you juxtapose them, it just does not work. We have a parliamentary democracy and statute law versus a written constitution in the United States of America and all of the different issues that flow from that. And then to juxtapose and set upon that another layer of, oh, this is about fear because of what happened with Roe and Wade, a completely separate issue again. I think it is naive to say that we should then try and change our whole system to embrace and to address this issue because of what has happened in the United States of America. It would be far better having a much more open and honest debate rather than one that is based upon fear of something which might happen. Of course, I will give way.
Thank the honourable gentleman for giving way. And he's making a really important point about not having misinformation. And would he agree with me that we have to be very careful in this debate not to conflate deregulation with decriminalisation, which I think is what's happened in a couple of the earlier contributions. He will know from Northern Ireland that whilst we've introduced decriminalisation, that has not deregulated the controls that are there for abortion. And that's a really, really important point.
Thank you, Sir Charles. And that is an important point. I will come to it later on whenever I touch on the matter of decriminalisation. There were 214,869 abortions in England and Wales in 2021. I looked that up. That's about 40,000 people short of the population of Walthamstow. Just think of the number. If you were to line them up, the vast array. You know what that says to me, Sir Charles? The utter abysmal failure of abortion regulations in the United Kingdom. The utter abysmal failure of abortion regulations. Why so many? Why, after years, decades and decades and decades of this regulation, why is that so necessary? 214,869 women felt it was necessary to have an abortion. I will, of course, give way.
I sympathise with the honourable gentleman, but he's not really going to carry the House with an argument that says that the number of abortions is equivalent to the human population of a city, when a vast proportion of those abortions will be at a very early stage of barely fertilized eggs. And although I see people on the other side nodding in agreement with me, equally to them, I would say, the demand for an absolute right of abortion similarly in reverse fails to recognize that a very late-term abortion is killing an embryo which is viable. And that's why this is a dialogue of the deaf.
Well, I'm sorry the honourable gentleman feels it is a dialogue of the deaf. I don't think that is the case. I think it's important that we actually, for the first time in a long time, are actually having a sensible debate in this matter, because in numerous debates in this House in the past on abortion, people have been silenced. Principally, male members of the House have been silenced on what has been said. They've been called out, they've been heckled, they've been told not to speak on issues that doesn't concern them. Indeed, but the comments earlier in this debate today that abortion, that behind every abortion is a woman, full stop. No. Behind every abortion, behind every pregnancy, is not only a woman, it's the life of the unborn and the male who was involved in that pregnancy. And until we have a full engagement and educational process that addresses those issues and gets this nation to speak about that, not in a climate of fear, oh, I better not speak out, we're not allowed to say these things anymore, they're too difficult to say if you're a man. Unless we get into a proper debate in this matter, as we should, then I'm afraid this will be a debate of the deaf. But it doesn't have to be. I think that's the point, of course, I will give way.
Honourable friend for giving way. He's making a very powerful speech. Men do matter. You're absolutely right. 82% of all abortions last year were for women whose marital status was given as single. I actually commend those men who support their partner and their child, and we need more men to do the same. And this House is at risk of silencing those men who do actually stand up and take responsibility within pregnancy.
I thank the member for her point. In 2022, there was double the provision of abortions in Northern Ireland than the year previous. And that is a number which doubles each year and will continue to double in Northern Ireland because of now the very liberal legislation that is now in place in Northern Ireland. I think another member put on the record that 1 in 4 of all pregnancies end in abortion in the United Kingdom. In England and Wales, the right to abort is up to the very extreme limit of 6 months. 6 months into pregnancy, yes, I still wish to have an abortion, whereas the European medium time limit is 3 months. And I think we do need to have a debate around those issues as to why we have an extreme time limit and why there's some people who wish to drive it even further to the point of birth as a point of right. I just think that that's wrong. You know, we need, Sir Charles, most certainly we need to have a debate on why there is so much abortion in the United Kingdom. If I could go back to the point and answer my friend and colleague here, that why are second and third time pregnancies. Why is that leading to abortion? Older woman leading to abortion. Why? Those questions need to be made. We need to have those. It can't all be ectopic. It can't all be rape. It can't all be incest. It can't all be miscarriage. There's issues here. There's issues. No, I'll give way. Yes, I'll give way, but to your colleague first, and then to.
I thank him for giving way again, and he's very generous with his time. But a woman is, and he's right, nobody should be silenced, and that's what I wanted to achieve from this debate. And everybody has got a choice, but it is ultimately the woman's body, and it's ultimately the choice, and we mustn't conflate that, because that is really important to women and girls everywhere, and not all have the privilege that we do to be able to have the comfort of bringing up a child.
I understand the point that the member's making, but of course it's 2 DNAs, 2 blood streams, 2 lives, 2 heartbeats. It is more than just the woman's body, and whilst I accept that the woman has a very difficult choice to make and is sometimes put in that horrible position by irresponsible and selfish men, that the choice to protect a life is something which sometimes women are talked out of. And I've seen that and I've heard that, and I want to make sure that that choice of allowing the life to flourish and to grow, and that there are other opportunities beyond the womb, that is something which we should, of course, be dwelling on. I will give way to the member from Walthamstow.
I thank the honourable gentleman for giving way. He and I have debated this issue in many different ways, and I know he's not meaning to sound like he's suggesting that it's okay if a man tells a woman she has to have the baby, but not okay if he supports her choice to have an abortion, because that would be the corollary of what he's saying. But does he recognise that when it comes to legalisation in Northern Ireland, we didn't just have decriminalisation, we didn't just take away the Offences Against the Persons Act, we also brought in laws to regulate how a woman could access an abortion. There is no late-term abortion. There is no sex selection in Northern Ireland. The Abortion Northern Ireland Regulations 2020 that our colleague opposite wants to cover precisely those issues. So it's not that enshrining a human rights perspective leads to no regulation. It removes the criminal element of our old regulation and allows us to have these very debates.
Thank you, Sir Charles. Well, of course, the issue is that the member cannot say there is no late termination because she does not know. The member cannot say that there is no sex selection because she cannot know. The law now masks that and does not allow you to know that thing because it is a right to have it as of a right, not because there is a reason. And that is the issue, indeed. And I know it's an issue which the member would like to have here. I know the member would like to have termination right up to the point of birth for whatever reason. And it is an issue. And it is an issue. Well, maybe the member doesn't want to write up the point of it, but she certainly wants the most liberal interpretation of the law that is possible. And we will disagree on that, and that is the case. But the attempt to silence people from having the conversation on this matter is, of course, morally wrong. And I hope that we never get to that position. I said I did want to touch, Sir Charles, on the issue of decriminalisation, because that has been an important point of this. And there are difficult cases. Of course, it is such a small number. The member touched upon 17 cases in, I think, 7 or 8 years in the United Kingdom. And yes, it's difficult for those 17 people who have been questioned on this matter. More difficult for the 2 people who have been charged. But let's deal with one of the cases where there was a charge brought, and that was, of course, the case of Sarah Gatt in 2010. And in that, the examples of women who had been prosecuted following long-term abortions, which include Sarah Gatt in 2010, took abortion pills at a 39-week gestation and then buried the body of the child. The judge in the case said, and I quote him, "All right-thinking people would consider this more serious than involuntary manslaughter or indeed any offence save murder," end of quote. And there was no remorse detected, said the judge. Now, how would that case be dealt with in a new dispensation where there is no criminalisation? Would we be creating a gap that would allow, a gap in the law that would allow for people to, quite frankly, get away with murder? Because that is the unfortunate circumstance. We also have circumstances where men wrongly try to enforce or encourage an abortion on a partner who is pregnant by hiding tablets, putting those tablets into their drink, spiking their drink, trying to encourage them to have a miscarriage, forcing that. This decriminalisation, how would a clever lawyer get those people off that particular charge? And it would happen. So I think we enter into this new dispensation of this rights base to put this into the Bill of Rights in the United Kingdom, which would be abhorrent in terms of the law. Because there are people who unfortunately do commit criminal offences, do commit it around pregnant women, are pregnant and do commit it, and the law should try to deal with it. And yes, deal with it sensitively, but deal with it proportionately. And I think 17 cases in 7 years is proportionate, given that we have about 900,000 pregnancies in the United Kingdom annually. Thank you, Sir Charles. Thank you very much. Jacob Rees-Mogg.
So a pleasure it is to be serving under your chairmanship and to speak on the debate so elegantly introduced by the Honourable Member for the Gower. I think there are two things to look at. First of all is the question of the Bill of Rights, which the Honourable Lady from Walthamstow said I might mention, because it is trying to impose an American construction on the British Constitution, and I don't think in that sense it actually works. The example I'd give is that it's much forgotten that the British Bill of Rights has a right to bear arms. It actually has a right to bear arms for the maintenance of a Protestant militia, which may be more welcome with some of the honourable members opposite than it is personally with me. The Second Amendment in the US Constitution maintains, I see the honourable gentleman from Strangford is nodding in favour of having a Protestant militia. The similar US Bill of Rights, its Second Amendment, maintains the right to bear arms, again for the purpose of a militia, and that has become an absolute in the US Constitution, whereas our right to bear arms has been gradually changed by Parliament over the centuries so that it is completely controlled. So I don't really see what the petitioners are trying to achieve in what they ask for. They want the right to be particularly protected, but that is not a protection. It's a protection protectionless, because any subsequent act of Parliament would automatically change it in whatever way Parliament decided. And therefore, as my right honourable friend, the member for New Forest West, correctly pointed out, there is no greater protection than being an act of Parliament, and that is already the situation as it exists. And there is not a majority in Parliament to change it. Whether there is a majority, and we've heard some opinion polling, would like to see it changed in the country at large, is another matter and a matter for debate, but the law is as solid as it can be from the point of view of those who are in favour of abortion laws as it is. And therefore I think the petition misfires on those grounds alone, and it would make no sense to introduce this into the Bill of Rights that the government is bringing forward, which is actually dealing with the relationship between the executive, the legislature and the courts, rather than trying to move to a codified constitution, which, as far as I'm aware, is not the policy of His Majesty's government. If it were the policy of His Majesty's government, I'm not sure I would be supporting it. But I think the Bill of Rights as proposed is a very sensible step in establishing how the executive and the judiciary relate now that we no longer have the ECJ sitting above us. But it's not right for this particular proposition brought forward by the petition. There is then the issue of abortion itself, which underlies obviously the whole of this debate. And it seems to me that it is the greatest sadness that the number of abortions that take place each year take place. The honourable gentleman, the member for North Antrim, pointed out it was 214,869 last year. I think all sides would agree that this is a matter for the deepest sadness. There is nobody who welcomes abortion. There is nobody who wants there to be this very high level of abortions. If you think of it over the period since the Abortion Act came in, over 10 million babies have been aborted. We know that in Northern Ireland there are over 100,000 people alive today who would not otherwise be alive had Northern Ireland had the Abortion Act that the rest of the United Kingdom had. And we know this to be true because the pro-abortionists complained about this and went to the Advertising Standards Authority, and as I understand it, the Advertising Standards Authority said the number being claimed was actually lower than the reality not overstated. So, to the point made by my right-hand friend, the member for New Forest East, he said we can't look at it in terms of numbers of cities and people like that. But we can, because there are over 100,000 people in Northern Ireland who are alive today, who would not be alive had Northern Ireland had the abortion rules that we have in England, Wales, and Scotland. And that seems to me to be a modern tragedy, that there is this number of people who are no longer, had no opportunity for a life because they were ripped untimely from their mother's womb. And when we think about this, and we think of the numbers of 214,869, in a four-year period, the destruction of life is as great as it was in the four-year period of the First World War. Those are the numbers that we are dealing with, and that is the tragedy of abortion. And, of course, I'll give way.
May I just slightly correct what he's just said? It's not the destruction of life in many cases, it's the destruction of potential life, unless one agrees, as I think he would agree with our honourable friend from Congleton, that life begins at the moment of conception. But most people don't agree with that. They believe it develops during the course of gestation. And that's why my right honourable friend and neighbour is right when he says that the embryo acquires rights along the way, but not from the outset.
Well, my right honourable friend raises the question of the viability of life. The viability of life, when does that start, Sir Charles? When do you think a life becomes a fully independent, created life? Perhaps my right honourable friend thinks that we should be like the ancient Romans, the newborn baby. Saint Marcina, who rescued newborn babies who were exposed in ancient Rome because their life wasn't viable without intervention, without support. They were allowed to die until the early Christians went and saved them, thought to be peculiar for doing so, particularly, as it happens, disabled babies. And we know that the abortion laws that we have allow for full-term termination, full-term abortion for babies with minor disabilities, as my honourable friend, the member for Congleton, pointed out. This is the tragedy of abortion, of the destruction of life. And my right honourable friend wants to quibble about when life begins, and I accept this is perhaps more a theological question. What is the start of life? But that new embryo has that potential for life. It has been formed as a separate being that is separate and different from the parents from which it came. And of course I give way to the Honourable Lady.
Grateful for the Right Honourable Member for giving way. Does the Right Honourable Member agree that in cases such as fetal abnormality syndrome, ectopic pregnancy, where the life of the woman would be put at risk, that abortion is acceptable to the Right Honourable Member in those cases? Or does those lives not matter?
The job of doctors is to save life. And it is quite clear that the job of a doctor to save life means that an ectopic pregnancy that may threaten the life of the woman carrying the baby is one where an intervention may be made to save the life of the woman. That is perfectly traditional and acceptable understanding of how you maximise the saving of life, but you don't pretend there isn't life, because there is. There are two lives, and I give way to my right friend.
Not to keep intervening, but I take a slight objection to the use of the word quibble. I readily acknowledge that there is a vast uncertainty and grey area at the point, or at least the part of the spectrum, at which potential life becomes a viable human being. But just because you cannot identify an exact point in the process doesn't mean that at the beginning of the process, the fertilized egg is only a potential human being without the same rights as the viable human being at the end of the process has.
But the viable point is one that my right friend admits he cannot define. But there is that clear point of conception where you have a new genetic entity. It is unbelievably clear and straightforward. To say that there is some later date, and it may be 21 weeks or 22 weeks or 24 weeks, is not the heart of the argument. The heart of the argument is actually that this new life started at the point of conception, and the tragedy is the 214,869 lives lost last year. And, of course, I'll give way to the Honourable Lady.
Given the train of thought that he's coming up with, would he support the rights of women to choose to have an abortion were they a victim of rape or incest?
I think the destruction of life is wrong. I do not believe that you should say that a new life should be destroyed. I do not believe that is the right of the state. And I think to put it in a Bill of Rights, even if we were the United States, even if we had a Bill of Rights that is the same constitutional standing as theirs, then my honourable friend, the member for North Antrim, is right. That he said that bills of rights are usually about protecting and preserving and ensuring that people are able to get on with their life. And this is about destroying life. This is the cult of death. It is the great tragedy of abortion, and that it is considered normal. And that this extraordinarily high number of babies that are destroyed is something that should sadden us all to the depths of our souls. And the idea that we would protect something that is so wrong and ignores that second life, and that we should say that that is an absolute right on a par with free elections, seems to me to be an absolute tragedy. So I think this petition misfires. I think it's wrong constitutionally, but it's much more wrong morally, because it prefers death to life.
Last but not least, from the backbenchers, Carla Lockhart.
Thank you, and can I say it's a pleasure to serve under your chairmanship, Sir Charles. And I would like to begin by making the following observation. Over this debate, it has become apparent and very clear that members lobbying to repeal the UK's abortion laws say that they speak for all women and that they are on their side. Of course, my remarks, I want to make it very clear that they don't speak for all women, and they certainly don't speak for the unborn. In fact, we hear little or no mention of the unborn, and only for those of us who are champions of both lives in pregnancies, we would hear nothing of the unborn from the lips of those who pursue their pro-choice agenda. I've just started. I will continue. I'll give way throughout the call. So I want to make it very clear that they don't speak for all women, and on focusing on some women who I don't believe they speak for, I'm going to give some examples. And that is one young woman, Mallory Bantala, refused to have an abortion and was violently assaulted by her ex-boyfriend, Kevin Wilson. When she returned home from her baby shower, she suffered life-threatening injuries, and her son was stillborn as a result. Caroline Craft, she had been in a relationship with Matthew Cherry, a former police officer, and they broke up when she refused to have an abortion. When she was 6 months pregnant, Miss Craft opened her front door to find an attacker who turned out to be Mr. Cherry, who punched her repeatedly in her stomach and back in a way that targeted her unborn baby to cause miscarriage. At sentencing, the judge remarked that this was an evil attack, which involved a high degree of planning. Fortunately, Caroline recovered from her injuries and gave birth to a healthy baby boy. A jury convicted Mr. Cherry of attempting to cause grievous bodily harm with intent, and he was sentenced to 10 years imprisonment. And finally, Lauren Oliver, when she was 34 weeks pregnant, her ex-partner, Nicholas Leaning, a professional cage fighter, stabbed her 5 times in the stomach in an attempt to kill her unborn child. Again, the details of this case are chilling. Miss Oliver and Mr. Leaning had just broken up when Oliver learned she was pregnant with his child. When she refused to get an abortion, he said he would kick it out of her if he had to, and he did, not wanting anything to do with the baby. An emergency C-section delivered her baby 6 weeks early, who astonishingly was unharmed in the attack. And a jury found Mr. Leaning guilty of wounding Miss Oliver and attempting to destroy the life of a child. He was sentenced to 19 years imprisonment. As these cases demonstrate, the laws we have in place are being used to prosecute often violent men and protect women from serious forms of violence. This new dispensation would take away those protections for Caroline, Lauren and Mallory. They ensure that the Kevin Wilsons, the Matthew Cherries and the Nicholas Leanings of the world are punished for their despicable crimes. How can members who seek to repeal the UK's abortion laws claim to be on the side of women and yet stand in opposition to these women who have suffered life-threatening injuries at the hands of these violent men? According to the charity Best Beginnings, over a third of domestic violence starts or gets worse when a woman is pregnant. 40 to 60% of women experiencing domestic violence are abused while pregnant. 15% of women report violence during their pregnancy. These are worrying figures. If we contemplate removing legal protections for these women, we would be profoundly letting them down, and when they are at their most vulnerable. We cannot let rhetoric replace the real protections in place for women. Throughout the debate, we've also heard many mention Northern Ireland and the laws that were forced upon the people of Northern Ireland. These laws don't represent the people and the views of Northern Ireland. I will give way.
I thank the Honourable Lady for giving way, and she will understand that in this debate it was very important to choose one's words carefully, and we do think about all women, and we do think about the women in Northern Ireland, as well as the evidence session with the Women Inequalities Committee took evidence of them in the last Parliament. We must choose our words more carefully, because we are responsible, we are legislators, and we need to realise that we all care for all women. That is why we are here.
And certainly I can relate with that. I do care for all women, and I want to see a society that helps women to choose life. I want to see a society that wraps their arms around women who find themselves in a situation where they feel they have no other option. I want to see services improved for women who find themselves in that situation. But if we think of Northern Ireland and the laws that have been forced on the people of Northern Ireland, they are not what people want in Northern Ireland. And the very clear consultation results were 79% of respondents to the consultation on the legislation opposed the introduction of these laws that are some of the most liberal abortion laws in all of Europe. So it is just wrong to say that the people of Northern Ireland support these laws, and it has absolutely undermined the devolution process. The devolution process is there. Health is a devolved issue, and therefore should be left to the people of Northern Ireland. And I do choose my words carefully. I am from Northern Ireland, so I know exactly where people are at, and I know the views and the concerns that have been raised around the abortion laws. And we see continual attempts to interfere in Northern Ireland's abortion laws, and we're going to see it again tomorrow, even in the Executive Formation Bill. I would respectfully say, allow the legislators in Northern Ireland to do what they need to do on this, because it is a devolved issue. And when we are on statistics, it is important to note, again, has been mentioned a couple of times in the debate, the Comres data, where only 1% of people surveyed want the abortion time limit raised to birth. 70% of women would like the current time limit actually reduced. 59% of women would like the abortion time lowered
to 16 weeks. So it is wrong to say that the overwhelming view of women in Northern Ireland want this decriminalisation that basically allows for abortion to birth for any reason.
Would the member give way?
I will indeed give way.
Thank the member for giving way, and in doing so, in relation to the decriminalisation of and the abortion, murder, and I term it as murder, has been an issue. We had the Oma bombing, where the lives of the 2 unborn are included in the numbers of those that were killed, and those who were convicted will be charged with the murder of the 2 unborn babies as well.
I thank my honourable friend for his intervention. It was a very powerful point and one well made. Behind every abortion, we've heard in the debate today, is a woman who deserves choice, I think was the words used. I'm maybe paraphrasing, but it was something to that effect. I would say respectfully, behind every abortion there are 2 lives. And there is the life of the woman and the unborn. Unfortunately, the unborn doesn't have a voice. They can't speak. They can't speak up for themselves. They can't articulate the fact that they would choose life, because I know the unborn would choose life, because ultimately life is precious. I would respectfully ask to all of those who are involved in this debate, and even in the debate tomorrow, to respect the unborn. I will continue to be a voice for the voiceless, as many around this chamber today have articulated. And I would say that in every pregnancy, the most basic human right is the right to life. Thank you.
Shadow Minister.
Well, Sir Charles, and it's a pleasure to again serve under your chairmanship. I would like to thank my honourable friend, the member for Gower, for presenting this petition, but particularly for the sensitivity with which she did so, as she outlined the complexities thrown up by the petition and the role that a Bill of Rights could, or perhaps could not, further the rights of women, women's rights over their own bodies. And to Caitlin at the back of the room there, for the petition itself. Whether there are bigger campaigns at play around the world, around the country, whatever, I still think it's a great thing for democracy that an individual citizen can hold us all to account in this place through hard work and the dedication to their own particular cause. Now, so Charles, I completely understand and recognise the very real anxieties that have prompted this debate today. It's an outrage that 36 million women in 26 American states were stripped of their right to a safe and legal abortion when Roe versus Wade was overturned earlier this year. It was a devastating setback for women's rights in the United States. It reminds us that we must be vigilant in the protection of our hard-won rights, especially in the face of organised far-right campaigners who seek to roll them back. It wasn't until, it wasn't until 1967 that women in Britain won the right to a safe and legal abortion. And it was just 3 years ago that 99 MPs voted to keep abortion illegal in Northern Ireland, including the current Secretary of State for Justice. So I want to begin by affirming the Labour Party's commitment to a woman's right to choose. We believe that access to a safe, legal abortion should be available throughout the UK, and we will always protect and safeguard that right. Now, we had many contributions today. The Right Honourable Member for Gainsborough, he pressed the opinion that Parliament should remain sovereign in abortion policy, so perhaps he will also support decriminalisation. My honourable friend, the member from Walthamstow, she and I have had a few conversations or emails exchanged in the last 24 hours or so. She talked about that need for clarity on any rights under the Bill of Rights and stressed how it would still be subject to challenge. She talked about variable rights in different parts of the UK and the need for a consistent approach, but ultimately that need for a woman to have the right to determine what happens to their own bodies. And the Right Honourable Member for Basingstoke was supportive of the work to give women autonomy over their own bodies. I'm not surprised. I've heard her speak on many occasions. But she also summarised current legislation and also queried the investigation of medical abortions. Like so many people, she, of course, supports decriminalisation. The member for Strangford, a very different opinion, spoke of the need to respect each other's views, though, and explained what he saw as the view of the Northern Irish people and why legislators should be very mindful of that. The member for Congleton, the usual robust approach, defining her view, and she relied on international legislation and various treaties in support of her opposition to abortion in all its forms. But it was good to hear her say, in the response to my honourable friend, the member for Gower, that she did not believe that women seeking an abortion should be criminalised. The member for Pontypridd, yes, a healthcare right, she said, and I agree with that, properly funded and available service. She stressed that behind every abortion was a woman with a decision to make. The member for Blackpool South, well, he questioned the evidence that it is overwhelming public approval to decriminalise abortion, though I didn't hear why he actually believed that. The member for North Antrim, well, he stressed that men should be involved in any abortion decision rather than that being the women's decision alone. But he also raised the rights of a woman who a man may try to force to have an abortion against her will. The Right Honourable Member for North East Somerset, well, he spoke of what he believed was the cult of death. And then he said he would rule out abortion in all circumstances, including rape and incest. And the member for Upper Bann spoke of the need for women to be protected from men, and also stressed the horrific figures of domestic violence in her area. So Charles, a robust debate and lots of contributions.
He began his excellent summing up, if I may say, of the debate by quoting, I think, 126 million women who had lost their right to abortion. I don't want to get involved in the detail of US politics, but the reality is that many of those women will retain their rights under state legislation. It was simply a question of the federal right being removed.
Well, yes, and I don't disagree with the honourable member, but the fact remains that there are lessons for us to learn about what is actually happening in America. Now, Sir Charles, the introduction of the Human Rights Act is one of the proudest achievements of our Labour Party, and we are deeply concerned about the current government's attacks on it. So there are a number of reservations that I have on the mechanism that the petition proposes. Firstly, the government's rights remover bill. They call it a Bill of Rights. It's shambolic. It will divide the nations of the UK, weaken the rule of law, and create additional barriers for British people seeking justice. The End Violence Against Women Coalition described the bill as a major step backwards for victims and survivors' ability to seek justice and a direct attack on women's rights. They go on, we have long called on the government to save our Human Rights Act, which is an essential tool for upholding women's rights to live free from violence. It provides victims and survivors with essential legal protections, as well as vital tools to challenge the state and its institutions for failing to protect us from gender-based violence. UK in a Changing Europe, it's a UK-based network of academics and researchers, have also raised concerns that, and I quote them, the Bill of Rights bill would prevent UK judges from interpreting convention rights in ways that create positive obligations on public authorities. It added, many landmark cases under the Human Rights Act have relied on positive obligations. For example, the Act allowed bereaved families and survivors of the Hillsborough disaster to expose the negligence of state officials using the positive obligation to investigate alleged breaches of the right to life. Not only does the Bill of Rights preclude new interpretations of rights, this is a continuation of the quote, that impose positive obligations on public bodies, it also discourages courts from applying positive obligations that have already been identified in previous cases. This could lead to legal uncertainty and to divergence from the case law of the European Court of Human Rights, since positive obligations are an important principle applied by the Court to ensure practical and effective protection of rights, particularly for people whose rights are most vulnerable to abuse, such as children, victims of sexual violence and people seeking asylum. Everyone in this room will be familiar with the case of John Warboys, the black cab rapist who raped and sexually assaulted over 100 women over the course of 6 years. 2 of his victims challenged the Metropolitan Police's failures to stop his horrific course of offending by relying on the positive obligation under Article 3, the right to not be subjected to inhumane or degrading treatment. A UK court held that because of the obligations under the Human Rights Act, the police are under a legal duty to take reasonable steps to investigate credible allegations of serious crime. Labour will oppose this rights removal bill, which will see victims of serious sexual assault lose the right to force the police to investigate crimes committed against them. This bill is not about giving people extra rights, it's about taking our hard-won rights away, and we cannot lose sight of that fact. My second concern about the petition is that we cannot trust this government to properly safeguard such an important right in this particular proposed legislation. The Rights Removal Bill is the pet project of the Secretary of State for Justice and has only been brought back when he was reappointed to his former position. As I mentioned before, he himself voted with 98 other MPs in 2019 to keep abortion illegal in Northern Ireland. He has described the government's equality office as pointless and suggested it should be abolished. He even called feminists obnoxious bigots and defended the remark just a couple of years ago on the Andrew Marr show during his failed prime ministerial bid. This is not a Secretary of State who has women's interests at heart. The final reason I do not think that the Rights Removal Bill is an appropriate mechanism for reforms to UK abortion law is due to its scope. Labour have committed to decriminalise abortion, that is to remove it from the scope of UK criminal law. There are 2 cases in which women will stand trial next year for accessing abortions in the UK. The maximum sentence, as my honourable friend, the member for Walthamstow said, is that if they are found guilty, it is life imprisonment. Now, a coalition of organisations, including the Royal College of Obstetricians and Gynaecologists, Amnesty International, Southall Black Sisters and the British Pregnancy Advisory Service, wrote to the Director of Prosecutions requesting the prosecutions be dropped and noting that over the past 8 years, at least 17 women have been investigated by police for ending their own pregnancies, though they believe the actual number is likely to be a lot higher. And as we heard earlier, last year, a 15-year-old girl was investigated by the police after an unexplained stillbirth at 28 weeks. She was accused of illegal abortion and reportedly driven to self-harm by the year-long investigation. Police stopped pursuing the case after a coroner concluded the pregnancy ended because of natural causes. As Claire Murphy, the Chief Executive of BPAS, put it, what kind of society treats women in this way? It is abhorrent that 160 years later, vulnerable women should suffer from legislation drawn up in a world which is unrecognisable to us now and punished for making decisions about their own bodies. It is not clear to us that the scope of the bill will allow for the reforms that we need to update our abortion laws so that they represent the values of our modern Britain. But I want to underline once again that the Labour Party supports women's right to choose and also wants answers from the government about how they plan to make UK abortion law fit for the 21st century. The Tories are taking the UK backwards with this so-called Bill of Rights. Labour will fight tooth and nail to uphold the rights of British citizens by defending the Human Rights Act. We already saw the previous Lord Chancellor commit the bill to a very slow back burner in the hope everyone would forget about it. No one can defend the indefensible. This Tory government and Lord Chancellor have got their priorities all wrong, with a bill which is about taking away our rights rather than being the vehicle for enshrining new ones. Instead of bringing forward the much-awaited Victims Bill, the Lord Chancellor seems to be determined to press on with his divisive Rights Removal Bill, which will make life tougher for our citizens, not better. What is clear, Sir Charles, is that from this petition and ensuing debate, however, is that the government must do more to support women's rights. And so I will be very interested to hear the Minister's thoughts on how the government will engage with women and women's groups more to address their concerns and ensure their right to choose is protected.
Thank you, Shadow Minister. Minister.
Thank you very much, Sir Charles, and it's a pleasure to be back in the Ministry of Justice after an absence of about three and a half years, and returning to some of the issues that I originally dealt with when I was last a Minister there. I'd particularly like to pay tribute to and thank the Honourable Lady, the member for Gower, and the Petitions Committee, both for this debate being before us today, but as other honourable and right honourable members have said, for the very, very measured and thoughtful tone in which the Honourable Lady made her opening remarks to the Chamber today, and indeed to all members for their attendance and their contributions today. I'm always conscious in debates of this sort that I am speaking as a minister reflecting the position of Her Majesty's Government rather than necessarily my own personal views on particular issues, and I will always seek to tread that very careful line. I'd also like, Sir Charles, to congratulate the creator of the petition, Caitlin, who I had the pleasure of being introduced to earlier this afternoon, for what she has done, and to the 150,000 people who signed that petition. Whatever views, and there are different views, we've heard them today expressed across this chamber, she and those who've signed this petition, I think, have done us all a service, and through the Petitions Committee, in allowing this issue to be debated here today, reflecting as it does something on which, in the country, among our constituents, there are strong views, and indeed among honourable and right honourable members, and we've heard those views expressed here today. Those views are strongly and sincerely held, and it is right that all those views are listened to with care and respect in this place. We've heard the honourable gentleman, the member for Strangford, setting out very clearly his perspective. We've heard the honourable lady, the member for Walthamstow, setting out hers. My right honourable friend, the member for Basingstoke. My honourable friend, the member for Congleton. All very different perspectives on the same issue, but all important perspectives on that issue, reflecting different strands of opinion in our country. And it's right that this chamber, that this House, hears those different perspectives and debates them properly. Let me emphasise at the outset that this government is committed to ensuring access to safe, regulated abortion, that all women in England and Wales have access to regulated abortion services on the NHS under our current laws, including taking both abortion pills at home where eligible. And I would just gently say to honourable and right honourable members, I think it is important that a degree of caution is shown by honourable and right honourable members in interpreting the motivation behind the votes of different honourable and right honourable members on some of the particular issues we've heard talked about today, because in some cases honourable members will have voted, for example, against the changes around abortion at home, for reasons perhaps reflecting the process by which that was done and the preference for a review, a medical review, and the Secretary of State taking that decision. Those people may then have voted in favour of buffer zones around abortion clinics. So I do think we need to be very careful and perhaps not go down the route that some websites, some online platforms go down, of reading a particular vote and extrapolating from it what that member must think about the whole issue. The votes, as all honourable members know in this House, are often on complex and detailed questions, and indeed often on complex procedural or constitutional points. So I just say that I think we need to be cautious in those interpretations. Access to abortion in England and Wales has been settled in law by Parliament, and we do not intend to change this. It takes nothing away from our commitment to ensuring access to safe, regulated abortion, to say that the government does not intend to include a right to abortion within the Bill of Rights as the appropriate approach, and I will set out why. We've heard different reasons around that, and indeed we've had Honourable and right honourable members speak strongly in favour of changes, but equally recognising this may not be the best mechanism for those changes to come about. Now, the petition references the recent judgment of the Supreme Court of the United States in Dobbs versus Jackson's Women's Health Organisation, in which the court overruled its own 1973 judgment in Roe versus Wade, finding that the US Constitution confers a right to have an abortion. While I will hesitate to stray into US politics, I can understand and appreciate the concern that that ruling has given rise to around the world. And we've heard that expressed, and we see an element of that expressed in this petition, the genesis of this petition. So the first point I want to make, Sir Charles, in response to the petition, is that the context in the United Kingdom is very different from that in the United States. And what has happened in the United States does not affect how abortions can and do occur in the UK. And indeed, we're actually seeking to avoid finding ourselves in a potentially analogous situation to the US. Now, I was going to make the point about the different historical evolution, shall we say, of the concept of a Bill of Rights, both in the American context and in an English or United Kingdom context. My right honourable friend, the member for North East Somerset, has done so rather more eloquently and probably with a degree more erudition and knowledge than I have. But I do think it is worth highlighting the different democratic and legislative traditions of our two countries. In the United States, the Bill of Rights is essentially an amendment to an adjunct to the Constitution, which is the founding document of the United States. In this country, we had our 1689 Bill of Rights, alluded to by my right honourable friend, but we also have the parliamentary tradition, and that very clear protocol that no parliament may bind its successors. And therefore, we are looking at two very different things. So I think we just, again, need a degree of caution about conflating with this Bill of Rights and how our legislation works in this country with the, for want of a better way of putting it, inalienable constitutional rights as conferred by the US Constitution and the Bill of Rights. Did the Honourable Lady want to come in on that or not? I thought I saw, I may be tempting her. Okay. I'm grateful to the Honourable Lady, although I suspect I'll hear from her in a moment. Access to abortion, and I should say I'm grateful to the Honourable Gentleman for his kind words about me personally. We'll see when I finish my speech whether he wishes to reiterate them or not. Access to abortion in the United Kingdom is, of course, not founded upon a court ruling. Instead, it's been clearly and specifically prescribed in legislation set by Parliament in the context in which my right honourable friend has set out and which I have alluded to. I will very briefly, and I know honourable members and the Shadow Minister to a degree, have set out the context of abortion law in England and Wales, but I will just very briefly reiterate it. But before doing so, I should, of course, highlight, as has been done, that the responsibility for the legal status of abortion was devolved to the Scottish Parliament through the Scotland Act 2016. And, of course, abortion, and we have heard from honourable members from various constituencies in Northern Ireland. Of course, abortion was also devolved to the Northern Ireland Irish Assembly through the Northern Ireland Act 1998, amendment of Schedule 3 Order 2010. And the treatment of abortion in the criminal law was devolved to the Northern Irish Assembly in 2010 following the agreement. Therefore, I should make clear that when I refer to matters concerning the law in relation to abortion, I am speaking to its application in England and Wales in this context. The Abortion Act 1967, amending or building on two pieces of legislation, I think it was one honourable member who referred to the age of that legislation, the 1861 Act and the 1929 Act, which updated it. The Abortion Act 1967 allows for safe and lawful abortion in England and Wales. It defines the criteria under which abortions or terminations can legally take place. And in effect, lawful abortions can be carried out in the first 24 weeks of pregnancy where two doctors agree that the abortion is necessary, as it falls within one or more of four grounds. I won't set them out in detail here now, but will say that in essence they concern, as we've heard from honourable and right honourable members, the risks to the physical or mental health of the pregnant woman, or risks that the child would suffer from significant physical or mental abnormalities. There will be strong views in this chamber, as we've heard, on those tests. There are also strong views, as we heard, and I should have said this in highlighting at the beginning the strength of opinion, on the right of a woman to choose, but also the very strongly held beliefs about the rights of an unborn child. And again, I emphasise the fact that I respect the sincerity and strength with which those views are held. Yeah, of course I will. Always to the right honourable lady.
My right honourable friend for giving way. He's making a really important case, but underlying all of our legislation is regulation, which ultimately is is how the law works. That regulation is not, I think, under debate at this point. What we're talking about, well, what I was certainly talking about, Sir Charles, in my contribution, was the fundamental framework of the law. Is he comfortable? Is the government comfortable with the fact that English women are treated as potentially criminal when they access abortions, yet this government has legislated to ensure that women in Northern Ireland are not treated as criminals? Does he think that's fair?
Minister. Well, if my right honourable friend will give me a little space, I was going to come to her remarks on that and also on the Department of Health's position. What I would say, in respect, though, just briefly on her final point there, is that the legislation in Northern Ireland, what we have recently seen, was the implementation of the will of Parliament rather than the government taking a particular, and I will come to that, and she tempts me in her remarks earlier to for the government to take a particular view on this issue. I will turn to that in a moment, if she'll let me make just a brief bit of progress, but I will, of course, address her points. In practice, the framework means that access to an abortion is available to those who need and want it. And abortions above 24 weeks are also possible in more limited circumstances, and it is, of course, open to Parliament to change the law if it so desires. As previously mentioned, abortion law is devolved to both the Scottish Parliament and the Northern Irish Assembly. I would usually not set out the position of a particular devolved administration on a matter, but due to the relevance to this debate, I will speak very briefly to the recent changes in Northern Ireland that my right honourable friend alluded to in her intervention just now. The Abortion Act 1967 did not extend to Northern Ireland. Instead, abortion law in Northern Ireland was provided under Section 25 of the Criminal Justice Northern Ireland Act 1945, which was equivalent to Section 1 of the Infant Life Preservation Act 1929 in the rest of the UK. The Northern Ireland Executive Formation Act 2019 decriminalised abortion and repeals Sections 58 and 59 of the Offences Against the Person Act 1861, the first of those pieces of legislation I referred to earlier. Following this, the Abortion Northern Ireland Regulations 2020 came into force, meaning that those in Northern Ireland who wish to can access an abortion on demand in the first 12 weeks of their pregnancy and can conditionally access an abortion up to the 24th week of their pregnancy and beyond this, again, in more limited circumstances. Those changes were made because of the very specific context there, and the amendment, I believe it was, brought forward around abortion in Northern Ireland, and it was therefore, given that will of Parliament, it was felt right that women across the UK should have safe and legal access to an abortion, and the will of the House should be respected in that respect. In terms of, before I turn to abortion in the context of the Bill of Rights, I will turn to some of the points made by may I just turn to my right honourable friend's points in her speech, and then I will, of course, give way to the honourable gentleman. Now, my right honourable friend, the member for Basingstoke, was right, and I agree with her that this is a very complex area, and she highlighted that in her remarks. She did, however, call for government to set out a clear, full and complete framework for moving forward this. It remains the position of the government that this is a matter for Parliament and remains a matter for the consciences and the decisions of individual members of Parliament. I don't like to disappoint my right honourable friend, and I seek not to do so. I fear on this occasion I have done, but I seek not to generally, but I fear I must do on this occasion. She did raise another question, if I recall, which I think was about the Department of Health and the action plan. in this space. It's been 3-4 months since I was last in the Department of Health. My memory is not entirely rusty. I do know that this is something that the department has been very much thinking about, but I would flag that in the last 3 years, sexual and reproductive health services have faced numerous new challenges, including those arising from the COVID-19 pandemic. We saw some of that reflected in the recent amendment on abortion and pills at home. I am advised that my honourable friends, ministers in the Department of Health and Social Care, are taking the time to fully engage with stakeholders from across the system to understand the impact of that new context in any plan they bring forward. But I do know from previous conversations with my right honourable friend the strength of her feeling on this, and I will ensure that that is conveyed to my right honourable friend, the Secretary of State for Health and Social Care, with the imprimatur, if I may, from her that speed is of the essence, and she looks forward to seeing that plan coming forward. I will turn to the specific question raised by the petition, whether a specific right to abortion should be established in the Bill of Rights. Yes, of course, I beg your pardon.
I thank the Minister, and I know the Minister is an honourable man, and I always have that opinion of him, and everybody in the House has the same opinion. But government consulted with the people of Northern Ireland on the abortion changes. 79% of those people who replied to that consultation were against any changes. Minister, if there's no intention to acknowledge or take on board the opinion of people in Northern Ireland when they're very much against the changes, why bother?
Well, I'm very grateful to my honourable friend for what he says, and I do appreciate the strength of feeling on this issue, and I know that when that amendment was brought to the House, there were a number of honourable and right honourable members, I suspect, who voted against, not because they did not support the rollout of safe abortion services and access to safe abortion services, but because of concerns about the devolution settlement and the nature of how that operated. The House expressed a very clear view, and it is right that that view is respected, and that is why the government has moved forward with the regulations that we have seen enacted. Yeah, I will, very briefly. Yes, I will, actually, plenty of time.
He's indicated that he's going to speak with his colleague, the Secretary of State for Health, about views raised on the sexual and reproductive health rights issues that are being considered by the department. Would he also, when he conveys the points made by the Right Honourable Lady from Basingstoke, also convey that the majority of colleagues who have spoken and stayed in this 3-hour debate today have expressed considerable concern about any extension of abortion rights in this country?
Could I just remind the Minister to sit down at 7:28? The Honourable Member for Gower had 2 minutes at the end.
I'm very grateful, Sir Charles. It's my intention to sit down sooner than that, to give the Honourable Lady, the Member for Gower, plenty of time for her remarks. I'm grateful to my Honourable friend for the point she makes. The specific issue I was going to raise with the Secretary of State was the very specific point made by my Right Honourable friend, which was about the delay in bringing forward that action plan, which had been spoken about prior to the pandemic. But I will, of course, ensure that he is made aware of this debate and the transcript of it, and I would encourage any honourable or right honourable member from either side of the House actually to take the time to read the transcript of this debate, because there have been very thoughtful speeches on both sides of the debate. The government believes that it is right the position on abortion remains something that is settled by legislatures and by elected members of this House, as it is now, without necessitating the creation of a specific right. And my right honourable friend is correct in shorthand, if I may. I'm not sure if shorthand is necessarily one of his fortes or natural stars, but he is right when he highlights what the Bill of Rights is about, which is about clarifying the balance of rights, the balance between the executive, the legislature, and the courts, and ensuring that we update that framework in a way that it reflects the current circumstances and remains effective. And as this debate itself has demonstrated, it's the legislature, rather than the courts, who are in turn, of course, directly accountable to our citizens and their concerns, and to the very strong views, as I keep emphasising, that our constituents have on both sides of this debate on this matter. We continue to take action to ensure access to safe legal abortion. For example, on the 30th of August, following the vote in the House, new provisions came into force that permit home use of both pills for early medical abortion on a permanent basis for women in England and Wales. On the 24th of October, the Secretary of State for Northern Ireland announced that the UK government will be commissioning abortion services for Northern Ireland, recognising, as he did, it is unacceptable that women are still travelling to the rest of the UK to access healthcare to which they are legally entitled following the decision by this Parliament. Including a specific right to abortion in the Bill of Rights would, we fear, mean that challenges could potentially be brought involving courts in measuring the compatibility of that legislation with this specific new rights. It actually risks taking us down the route of moving debate around abortion from Parliament to the courtroom, and I know that honourable and right honourable members may take a different interpretation of that. I did promise the honourable lady, and I will honour that promise. I may regret it, but I'll honour it.
I thank the Minister for giving way. I note we haven't yet had a satisfactory answer to the question posed by my friend from Basingstoke about why it is acceptable that our constituents in Walthamstow and Basingstoke face a criminal foundation in securing an abortion that they don't have a right to, but women in Northern Ireland have a human rights foundation to that healthcare. But can I just challenge him a bit more on this point about that somehow if we were to include these rights in this Bill of Rights, this would lead to litigation? He will note, of course, there is already repeated litigation about abortion rights and the balance of rights around abortion anyway. Why is abortion any different to freedom of speech? He will recognise that people have very strong views about the application of freedom of speech, so much so that this government has decided to bring forward its own bill on freedoms of speech, for example, in higher education. Why is it when it comes to women's rights, these matters are complicated and can only be dealt with by judges, but when it comes to freedom of speech, for example, we accept that there should be a parliamentary process and a piece of legislation whereby these matters can be resolved?
Well, I'm very grateful to the honourable lady. There's 2 points in there. I will address, if I may, the point made by my right honourable friend perhaps more explicitly than I did previously, that the honourable lady highlighted. We have been clear throughout this that the decision taken in Northern Ireland was a decision by this House. It is open to the House if it wishes to change the position in respect of England or Wales. We do not believe that that is something the government should do. We believe it is, as ever, a matter of conscience for individual members to do. And what happened in the case of Northern Ireland reflected the vote of the House on a particular amendment. I'm not going to use the word hijacking because I think that honourable and right honourable members are entirely well open to using the procedures of this House to advance the causes that they or their constituents wish to promote. That's how the rules and the standing orders of this House are written. So that is, while I may or may not be happy with it on occasions, it is a legitimate use of the standing orders of the House of Commons if something is within scope. To her, can I just briefly finish answering the honourable lady? Her second point, where she talks about rights, essentially, it is, as I say, it comes back to the point that it is entirely open for the House to legislate in prime legislation. She talked about free speech and the bill currently going through, just as with the 1967 legislation, which I believe was a private member's bill, again, by the now Lord Steele, promoted by the now Lord Steele. It is, again, entirely open to the House, through private members' legislation, through the usual processes that are followed for this sort of legislation, to seek to legislate. Just and a final point before I give way to the Shadow Minister, of course. In terms of the rights and the changes to rights, and it actually links neatly to what the Shadow Minister was talking about, in terms of the Bill of Rights. Actually, you will find at Schedule 1, Schedule 1 of the draft Bill of Rights actually includes the rights contained in the ECHR, which was set out in the HRA 1998. So I would suggest to him that while there is a focus on ensuring the right balance is struck between the legislature, the courts and the executive, a little caution about suggesting that this is anything other than updating and clarifying some of those balances.
Shadow Minister.
I'm grateful to the Minister for giving way. I want to be rather more blunt than maybe my honourable friend. Does the Minister foresee an early opportunity for the House to make a decision on whether or not abortion should be decriminalised?
Minister.
I'm grateful to the honourable gentleman. There are many opportunities in front of honourable members where they wish to submit private members' bills. When the new session starts, there will be a new ballot. And going to the point, the honourable lady, while I may take a view as to whether amendments should or shouldn't be included in particular pieces of legislation, if they are ruled by the Speaker in order, honourable members will explore options that they may or may not have. I do not believe that this bill, the Bill of Rights, is the right approach to take to securing this, if that is the desire of honourable and right honourable members, and that there are other mechanisms within Parliament for them to seek to advance that debate and propose legislation should they wish to do so. I would conclude by reiterating that this government remains committed to ensuring access to safe, regulated abortions. It's right that women have this choice at their disposal, and I'm sure that I speak, I think, for the whole chamber when I say that I do not want to see a return to unsafe, unregulated abortions, putting women's lives at risk or women feeling unable to escape the situation they find themselves in or unable to have an alternative. The debate today has, as I have said in my opening remarks, been thoughtful, I believe, on both sides of the argument. I believe it has been respectful, and I believe it reflects the depth of sincerely and strongly held views on both sides of this debate. So I've sought also to address the specific point of this debate in the context of the Bill of Rights. I slightly sidestep. I suspect that the Shadow Minister and I will have an opportunity in the coming weeks or months to debate the broader points of the Bill of Rights. So I've sought to keep my remarks to the matter in hand and to the specific petition. With that, Sir Charles, I am grateful for the opportunity to have spoken on this, and of course I look forward to hearing the Honourable Member for Gower's winding up comments.
Mr. Antoniazzi has at most 2 minutes. Can't fill all the time.
Thank you, Sir Charles. And I'd just like to thank the petitioner and the people that have signed the petition for their interest and the need to address the Bill of Rights and abortion. So in the context of the Bill of Rights, I do thank the Minister for his comments. And I would like to thank everybody who participated in this debate. I do think that we have a long way to go, and I believe that we can continue to have this debate and engage with more members across the House, because where it comes to such debates as assisted dying, sex and gender and abortion, where such difference in views are held and shared, I think that it is our responsibility as legislators to be able to discuss them and to move forward for the benefit of everybody that lives in the United Kingdom. Thank you, Sir Charles.
Thank you for that very concise bit of winding up there. The question is that this House has considered E-petition 619334 relating to legal rights to access abortion. As many of that opinion say aye, of the contrary no, I think the ayes have it, Order. Thank you very much.
Grand Committee room.
The proceeding has ended. The proceeding has ended. The proceeding has ended.